Is audio on? I can't hear you.
You're on now, Dave.
Okay, good. Thank you. How you doing? Nice to see you.
Good to see you too.
Hello, David.
Gotcha. It's weird because I'm not looking at anybody. Good morning. Welcome to the Joint Standing Committee on the Judiciary. Here today to conduct work session on a number of bills left when we left here in March. Before we begin, I would ask the members of my committee to introduce themselves, beginning in the back of the chamber with the representative from Bangor, Representative Cardone.
Barbara Cardone. Yeah, this is gonna. Barbara Cardone, House 127, Bangor.
Rachel?
Good morning. My name is Rachel Talbot Ross. I proudly serve House District 40.
How do you do? Good morning. My name is Christopher Babbage. I represent House District 8, which is part of Kennebunk.
Jeff? Yes. Turn off your mic on your computer.
Representative Jeffrey Evangelos, House District 91, Friendship, and my Zoom's warming up. I'll be with you in a minute.
Okay. Representative Harnett?
Good morning. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner.
And you are not quite on the screen. I assume you realize that.
Yes, I do.
Okay. Senator Bellows?
Senator Shanna Bellows, Senate District 14, 11 towns in southern Kennebec County.
We also have a number of committee members who are attending remotely. Representative Hagan?
Hi, Dave Hagan, House District 101, Hamden and Newburgh. Thank you.
I wasn't going to say anything about the dress code. That's okay. Senator Keim?
Good morning, everyone. Good to see you. Lisa Keim. I proudly represent Senate District 18, which is much of northern Oxford County and 2 communities in Androscoggin.
Do we have any other committee members?
Yes, it's
Oh, I'm sorry, Lois. Apologize. Yes, Representative Reckett.
Lois Reckett from District 31 in South Portland.
Currently sitting in the ocean end of South Portland, I assume.
Yes, yes, I am. You're right. But fortunately not in the ocean, although it's
Right. I want to make that
temperature
distinction.
of the
Thank
air
you.
today, they say.
Thank you. Other committee members that I don't see, I apologize. This is new to me. I'm not the high tech guy here. That's why I have my capable House chair who's about to introduce herself.
Good morning, everyone. I'm Donna Bailey. I represent House District 14, which is part of the wonderful city of Saco. And as Senator Carpenter mentioned, I am the House Chair.
And also helping us through this are some awesome folks from IT. I don't know their names, but thank you very, very much. Also, our ever loyal committee clerk was not able to attend today, Soupy. So we have Donna, is it Donna Semino? Thank you very much for helping us. And of course, the incomparable Margaret Reich, our committee analyst who's waving to us. So without any further ado, I think we're going to jump in. Peggy, was it your intention to start with LD 194?
That's how we set up the agenda, but we can go in whatever order you would like.
I don't have any reason to stray from your agenda, so take it away.
Great. So you should have all your files if you're in the State House, but you should, and I've emailed things to everybody, all the committee members. And we've also posted everything on the Judiciary Committee's webpage. So anybody who doesn't have that should be able to go over to the Judiciary Committee's webpage and pull up these documents. But for now, we're just going, I can also try to share my screen if that's helpful, but we're going to look at in your packet. I didn't put them actually in your LD files, LD 194. You had actually voted on this bill. This bill is, it's an act to allow the reduction of a main care lien. And you amended that bill. You voted to amend the bill to provide for some of what the bill was requesting, which was it provides that a main care lien applies to the portion of the award or settlement attributable to past medical expenses paid by main care. It can be reduced. Everything else can be reduced for attorney's fees. This had been negotiated very carefully with a lot of the interested parties, including the Attorney General's office, and you voted, and we were waiting for the fiscal note. And if you turn in your packet, you will see that the fiscal note is has a general fund cost of $544,000 in the first year, second year And there's also a federal expenditure fund cost to this. And so if you decide to go forward with this bill, you need to reconsider it and revote it to include an appropriation section to cover those costs.
Thank you, Peggy. Questions or comments for the committee? You have to raise your hand and signal to me if you, I don't see anybody. So in order to move forward, somebody needs to move to reconsider, I guess. Let me ask you first, Peggy, was the vote unanimous originally?
Originally, it was a unanimous vote and ought to pass as amended.
All right.
Make a motion to reconsider.
The chair recognizes Representative from Bangor, Representative Cardone.
Thank you. I'm the sponsor of this bill, and I thought I might be able to give you some information on this. If you will recall, we brought this bill, and the wording of the bill was carefully crafted to deal with or to address the issues of federal law. There's a U.S. Supreme Court case language that we incorporated so that our main statute is now in conformity with, or will be in conformity with, federal law. When I saw the fiscal note on this, I was livid. I think that the fiscal note is a fabrication. I'm not sure where it came from. And my original plan was to talk with somebody to address the fiscal note and have it adjusted to what I thought was much more reasonable. That we ran out of time because of our early adjournment. I've spoken with the Maine Trial Lawyers Association, who originally asked me to bring this bill. And here's what I think we should do. As a policy committee charged with policy, I think we should pass this bill because it's good policy. It brings us into conformity with federal law. As a practical matter, it's going to die on the appropriations table. And I think it will just be over and done with in this session. The Maine Trial Lawyers will plan to bring it again in a regular session when they have the opportunity to look at a more realistic fiscal note, and probably you'll be seeing it with the same language. So that's my thought, that we give it an ought to pass. It's not going to get funded. We all know that. So I was looking for a unanimous ought to pass, just so it could go under the hammer, die on the appropriations table.
All right, Representative Harnett.
I make a motion to reconsider.
Been moved by Representative Harnett that we reconsider our action whereby we voted on this bill. Is there a second? Seconded by Representative Bailey. Further discussion? Representative Harnett, I'm sorry. Senator Bellis.
This is just a question. Is there a quorum in the chamber for us to come back for the motion to reconsider? Should we do that now? Or, yeah. I can't see from the screen how many people are in the chamber.
I believe the quorum, once established, exists until somebody challenges it. Are you challenging it?
I am not challenging it.
Okay. I don't believe we need a quorum at this point for this motion. Anybody else have a question or a comment? Representative Arnett, did you have your hand up? Okay. All right, all those in favor of reconsidering, we're just going to do it by show of hands, I guess. Please raise your hand and keep it up until everybody's counted. It appears to me that every committee member present in the chamber or on Zoom have their hands up. Right. All right, thank you. All those opposed? Nobody else. All right, so the motion to reconsider prevails. I'm now looking for another motion. Representative Cardone.
I move that we amend to add the fiscal note.
Is there a second to that? Representative Arnett seconds it. Discussion? I don't have the fiscal note for some reason. At least I didn't immediately see it.
It should be attached to your amendment. That looks like this.
I have the amendment. I have,
And keep going through it. The fiscal notes on page 4. The appropriation section is on page 5. And
so the fiscal note's $544,650. General fund net cost in both years of the biennium. Further discussion?
And there's a federal expenditures fund cost of $955,800 as well.
Right. Discussion? Questions? All in favor of adding the fiscal note, please indicate this. Oh, I'm sorry, Representative Babbage, you had your hand up.
Unmute. There we go. Thank you very much. Could I ask someone, Peggy, is it possible you could explain to me the relevance of the federal funds to this bill? What I mean, I know that we're only concerned about the general fund fiscally, but what does it mean? What is the role of these federal funds?
My understanding is that there's a state match. So if you lose this, if you have those costs to the state Medicaid account, then you lose the 2/3 from the, or whatever that percentage is from the federal. So you'll lose that. If you don't collect that, you won't get that federal match. That's my understanding of how it works.
Thank you.
Senator Bellis.
Just a clarifying question, Peggy, is it you will lose the federal match on the entire sum or just on that portion of funds that gets reallocated?
That I'm not sure. I know that the fiscal office took into account the case law requirements that we should already be in compliance with, and they still identified these state costs and the federal costs associated with those state costs. I realize it's not a 2-to-1 exact match, and they were comfortable with these numbers. I'm not totally conversant. I'm sorry.
Other questions or comments? All in favor of adding the fiscal note to the bill, the motion to amend, which in fact does add the fiscal note? Peggy, go ahead.
I do think this is a situation where you're going to need, if anybody who is not in the room, if you don't have a quorum in the room, the rules are you need to have a quorum in the room to vote. And anybody who is not in the room is not recorded on the vote.
There you go.
So if they're in the State House and they don't join you in the House chamber, they can log their vote within 24 hours with the.
If you're in the building, I would ask you to make your way to the House chamber Otherwise, the folks that are remote, which I believe would be Representative Hagan, Senator Kime, you have 24 hours to notify the presiding officer of your vote on this, okay? Any questions?
Thank you.
Thank you. Thanks, Peggy. I forgot about that. So we're going to wait just for a second. I believe we have two members that are Representative Babbage. Would you join us?
Will do.
Senator Bellows is on their way. And I will try to give you a heads up in the future, a minute or two to get you down here. Senator Kime?
Thank you. Even though I can't vote at this time, I will be voting in opposition to this measure. So it is unlikely to just go under the hammer, as I think Representative Cardone was hoping.
Okay,
Thank you.
thank you.
So Senator Kime, can I just ask, will you be voting ought not to pass then? Or do you need a minority, an amendment?
Not to pass.
Ought not to pass, okay. And
Representative Hagan, did you have your hand up as well?
Yes, I will be joining Senator Kime.
Also not to pass?
Yeah, yeah.
Thank you. Thank you.
thank you.
Representative Babbage has made his way to the House chamber. I'm still waiting on. And if, I think we'll do a recorded vote. If Ms. Simoneau could make her way in to the chamber, please. Here she comes. Oh, that's right. All right. Would you call the roll, please, Ms. Simoneau?
Yes.
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 Thank you. Again, the two members who were not present have 24 hours to notify the presiding officer of your position on LD 194. Now, all we've done at this point is add the fiscal note. So I'm looking for a motion to move forward, ought to pass as amended, I'm guessing. Representative Cardone.
And move ought to pass as amended
Thank you.
with the fiscal note.
Seconded by Representative Talbot Ross. Any further discussion at this point on the bill, on the motion ought to pass as amended? If not, Ms. Simoneau, would you call the roll again, please? Oh, I'm sorry, yes.
Yes.
Yes. Yes.
Yes.
Yes.
Representative Babbage is on his way back down.
Yes.
So he can vote in person. I can't understand them. Oh, sorry. It's not just me this time. Here comes Representative Babbage. Representative Babbage, how do you wish to be recorded on the ought to pass as amended?
Yes, on ought to pass as amended.
Ought to pass as amended. Thank you.
Mr. Chairman?
Who?
That's Chris.
Oh, I'm sorry. Representative Babbage.
Yes, thank you. Just in the interest of, not to do with what just happened, but it takes me about 40 seconds to transport, and my constituents deserve a representative that hears everything that goes on. So I would appreciate being at ease during that 40 seconds so that I can hear any conversation or any explanations or whatever that takes place. I appreciate that.
I apologize. That was part of what I was supposed to do, and I slipped. I'll try not to let it happen again. I'll try to give you time to go back and forth, and we won't discuss anything while you're in transit. How's that? Thank you. Are we done with that one, Peggy?
I just wondered if Representative Reckitt wanted to comment on that because she's remote also.
Chair would recognize Representative Reckitt. Do you have anything you want to add, Lois?
No, just that I intend to vote yes, and I will call that in.
Thank you very much. You're up in the upper left-hand corner of the screen here. I'm not ignoring you intentionally, but you're sort of in the dark up there.
First yet, I'm going to be in criminal justice in a half an hour.
All right, thank you. Now, moving right along. Yeah, all I'm going to do now is to line up the next bill, and we'll wait for you to appear on the screen. The next one we're going to take up is LD 2034, Bill and Act concerning name changes for minors. All right, Representative Babbage is reseated.
Thank you very much.
You're welcome. We're going to take up 2034 next.
Yeah, 2034, hopefully this will be an easy bill. This is an act concerning name changes for minors. It is a bill that the Family Law Advisory Commission put together for you, and then they reworked pieces of it based on what the committee had recommended, and you voted unanimously in favor of this. At the same time you were doing this bill, there was another bill about name changes. That one got out the door a little faster and got enacted. We were trying to put exactly the same changes about when the probate court doesn't have to require listing all the notice when a name change is done. The other bill, all it did was it struck out the requirement that someone be a victim of abuse, of domestic abuse, and instead just left the one criteria. And if you're looking at the amendment, it's there on line 28. The person is currently in reasonable fear of the person's safety. Well, that other bill got enacted and became law. And what we still had in our amendment was striking out what is no longer part of the law. So this is pretty much as technical amendment as you can get to carry out what you wanted to do. All we're doing, the only change really is where I've labeled 2, where we show that paragraph A doesn't even exist anymore. But because we're changing what was in the bill, we need to do a reconsideration and a revote if you want to go forward with this as an ought to pass as amended. I would never tell you what to do, but if you want to go forward with it, those are the steps you need to take.
Thank you, Peggy. Members of the committee have questions? I'm scanning the screen. Representative Bailey? Do you have
Seeing no questions, I would make a motion to reconsider.
been moved that we reconsider our action whereby we move this bill ought to pass? Is there a second? Representative Harnett seconds it. Discussion? Any discussion? Representative Hagan?
Thank you very much. I just needed a little more clarification on this one. It's been a long time, and could we go sort of into the more details of exactly what we're doing? I apologize, but I just need more.
That's perfectly okay. Peggy, you want to come back on and walk us through this again?
So
Because
did you want more
still-
details about what the bill does overall? Or just
The bill
what
does
your little
overall.
technical amendment's doing here?
Yeah, what the bill does overall and the change, yeah.
So the bill provides, it does two things. It provides an avenue for name changes for a minor in various other situations other than just a straight name change. So it's things that a court considers in any other action where the child is involved. So it could be a parental rights matter. Right now, the only way to change a name is to go to the probate court, even if you have an action going on in district court. So what this says is so we're amending the probate code, and we're also saying, here's the process to change a minor's name. You have to use this process to change a minor's name, but the district court can use this process if it's an action happening in district court already. The whole home court act that went through a couple of years ago. So what it requires is, and what you spent a lot of time talking about was, what are the considerations when a name change is being requested? And do you have the amendment in front of you?
Yeah.
Okay, so on page 2 of the amendment, this is what you spend a whole lot of time on, is when they've requested a name change, here's what the court has to evaluate: the different factors. The court shall change a minor's name by agreement of all the parties. Or paragraph B, in the event that all parties do not agree to the name change, the court shall consider the following factors to assess whether the request or petition is in the best interest of the minor. So it goes through factors 1 through 6 that the court has to consider whether the name change is in the best interest of the minor. And if the court goes through all that and says, and factor 6 is any other factor the court considers relevant to the minor's best interests, and that references all the best interests that are normally considered by the court in any parental rights and responsibilities action in Title 19A. If the court finds that the name change is in the best interest of the minor by a preponderance of the evidence, the court then can proceed with the minor's name change. So
Okay.
that was kind of the gist of the bill.
Thank you.
You need more? Go ahead, Representative Hagan.
Oh, that's good. I appreciate that.
You lit up down here, so I thought you had something else you wanted to say. But I think that's based upon movement more than anything else. Other questions or comments from members of the committee? I don't see any other hands up. So help me out again. We're looking, the pending motion is to reconsider. All those in favor of reconsider, I'm sorry, go ahead, Peg.
Might I just suggest if that you go ahead and call people down for the
Okay.
reconsider
All right.
vote, and then unless there are any other discussion, you can go forward with the next vote and still have people in the chamber.
Okay. So if the folks who are in the building but distant would make their way here, please, we'll pause proceedings until they arrive. And then we will vote on the motion to reconsider. And if that passes, then we'll move immediately to the next vote, which would be ought to pass as amended.
Okay,
Thank you.
and I know Darlene Simino is running up from the first floor to take your votes.
Lots of exercise today. All right, pending motion before the committee is the motion to reconsider. Any further discussion? Darlene, you want to call the roll? Or do you, can we just do it by show of hands and she can count? All those in favor of the motion to reconsider, just indicate by a show of hands, please. Okay, 8, thank you. All opposed? Again, the folks, keep track of your votes, you folks who are distant. Senator Keim and Representative Hagan. Now I'm looking for a motion, a second motion. Ought to pass as amended. Representative Bailey, seconded by Senator Bellows. Discussion on ought to pass as amended. If not, Ms. Simino, would you call the roll? Yes.
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 Thank you. 8 members voting in the affirmative. Senator Keim, Representative Hagan, and Representative Reckett. There you are up in the corner. And Representative Bailey is now kicking me every time I miss you, Representative Reckett. So you will have 24 hours to call in to the presiding officer. Thank you. The next bill we're going to take up is the prosecutorial districts in Washington County, LD 1967. We'll pause for a minute while Senator Bellows and Representative Babbage make their way back to their remote location.
I'm here.
Are we ready? Okay. LD 1967, this is another bill that you voted. It is an resolve authorizing the establishment of prosecutorial districts in Down East Maine. Before we had our big delay in all our work, I was going to bring it back to you to show you new language about the effective date, which is added to make sure it's not considered a local government mandate. And what it does is it says the resolve is going forward to give only for the purpose of permitting the submission of this question to the voters of Hancock and Washington counties. Since we had the delay, and if you remember, this bill was to provide for an advisory vote by the citizens, the voters of Hancock and Washington counties to renegotiate possibly how the prosecutorial districts are set up, at least for those two counties. Create a new prosecutorial district for Washington County. And so this bill would authorize that vote going forward, and it's scheduled for the November election of this year. So since this is still sitting in front of you, Senator Carpenter asked if I would put together an emergency preamble for you. And so if that's something you want to do, then you would need to reconsider and revote this bill to include the emergency preamble. I did send it to Representative Toole, the sponsor. He was not sure if he was able to join today, but he's aware of this.
Yeah, and what I'm trying to do is I'm trying to accommodate Representative Toole. Because of the delay in our session, the language doesn't work. So this is what we're doing here is basically filing the divorce action, and then the next session of the legislature, they're going to come back with the language about how the settlement is going to go forward. And I believe Representative Toole is on board. I spoke with the sheriff in Washington County who had come down, Barry Curtis, who came down and testified strongly in favor of this bill. This is what they want to have happen. I don't know of any controversy about this one at all. Representative Hagan, are you still, or Senator Keim, have you had a chance to talk to Representative Toole about what we're proposing to do here?
I have not had a chance yet.
But you understand that we're trying to manipulate this so that it still would take effect at the time of the ultimate breakup here, if it's approved by the voters and the subsequent legislature. The breakup here would take place in 2024. Am I correct, Peg?
Don't know exactly when that would happen. I don't think the bill lays out. This is just the first step, and then any legislation would come back to the Judiciary Committee rather than the State and Local Government Committee as originally. Actually, you're right. The effective date of the legislation, they want it to be January 1st of 2023. So it would actually be coming in the next legislature, right?
Right, and that was to line it up with the next election of the district attorney for now Hancock and Washington, and then so get everybody lined up. Are there any questions? I'm looking for a motion to reconsider. Representative Bailey moves to reconsider, seconded by Representative Harnett. Discussion on the motion to reconsider. Representative Babbage and Senator Bellows, on your horses. We'll pause the proceedings while they join us.
Sorry. Okay.
You're not laughing at me, are you?
I am not laughing at you. Representative Babbage, his clean, safe room is the Veterans and Legal Affairs Committee, but because the door to that room is locked, he comes through this room. And he just informed me that he is liking this, going up and down the steps. So make sure you reward him for his physical efforts today. Just to let you know, this is the last bill, at least for a little while, that you've already voted on. So you won't have to reconsider 302, 1061, or 531. I think you were close on all those, but you hadn't actually taken any votes. So you won't need this two-step on the rest of the bills until we get to those LRs.
Senator Bellows and Representative Babbage have joined us. Ms. Simoneau is on her way, I'm assuming, so we'll wait for just a second. There she is. All right, on the motion to reconsider, I'm simply going to ask for a show of hands. All in favor of the motion to reconsider, please indicate by raising your hand. All set, thank you. All opposed? None opposed. We now are in a position to have another motion ought to pass as amended to add the emergency preamble. Moved by Representative Harnett, seconded by Representative Bailey. Discussion on the motion ought to pass as amended. Ms. Simoneau, if you'd call the roll.
Yes.
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 8 members voting in the affirmative, no members voting in the negative, and we have 3 outstanding votes to be called in within 24 hours. Thank you very much. Next, we're going to move right down the list here. We're going to take LD 302, but we'll wait for a minute for our distance runners here where Senator Bellows is handicapped because she has an injury, so she's got to get back down to where Abe Lincoln is looking over her shoulder.
Senator Carpenter, could you clarify where it is we're calling into?
I'm sorry, say that again, Lois.
Could you clarify where we're calling into? If we want to vote?
Be calling into the presiding officer's office, and the House members to the Speaker's office, Senate members to the Senate President's office.
Thank you.
Or I guess you can email. So if you're keeping track, you just want to put it all in one email, I guess you could do that. I wasn't aware of that. Thank you. Representative Bailey informs me that's for the House side. Senator Kyle, I think maybe if you call into the Senate President's office, they'll let you know whether you can email in or not. I don't know the answer to that. Babbage and Senator Bellows are now back in their position. We're now going to take up LD 302, an act to amend the law governing post-conviction review in order to facilitate the fair hearing of all evidence in each case involving a claim of innocence. Representative Evangelos' bill. Peggy.
Right, so you have in your packet, it's a 1-page amendment that replaces the bill. And what it provides is if it amends the law dealing with the time limits for when you can file a petition for post-conviction review while you're incarcerated, while you're when you're in direct impediment. And it adds a new subsection that says, hey, if we're talking about new evidence, look over here in this subsection 1. If the factual predicate of the claim is based on newly discovered evidence, then the claim may be filed at any time. So there's no limit once you find that evidence, regardless of when the newly discovered evidence could have been obtained or discovered through the exercise of due diligence. So that also covers the situation where somebody's counsel was ineffective and did not interview all the witnesses that they could have. So that might have been discoverable through due diligence, but it wasn't. The fact that it wasn't discovered is the important piece, and now it is. And this allows the person to file a petition for post-conviction review anytime after they have that newly discovered evidence. For this bill, we've actually extended an invitation to join your discussion at your discretion if you want to invite them to speak. Walt McKee from the Criminal Defense Attorneys and Don Maycomber from the Attorney General's office. They understand that they can't just jump in. It's not a public hearing, but they're here in case you have questions for them.
Thank you. Representative Evangelos.
Thank you, Mr. Chair. Do I have to unmute myself?
No, use your mic, use the chamber mic.
Chamber mic. There you go.
Okay, thank you. As the committee may remember, we were about in the ninth inning of reaching a consensus on this bill. And Attorney McKee had agreed to produce an amendment that summarized the feelings of the majority of the committee, I believe. I do want to put on record that on May 2nd, 2019, we received a letter from Maine's Attorney General stating that some examination of the post-conviction review system was warranted, and that, to quote the letter, the highlighted concerns included strict time limitations on when claims may be filed, the applications of the due diligence standard around Title 15, Section 2128B, and the extent of access to post-conviction review counsel. And that is exactly what Attorney McKee has addressed here. You remember we discussed the frustration of having a time run out to file an appeal when there was evidence to warrant it, when in fact in our cold case homicide unit there's absolutely no limitation on evidence that can be brought forward when we're trying to find a person who committed a homicide and was never caught. So it's a pretty straightforward amendment, and I would ask that Mr. McKee be allowed to weigh in on it. But I also am concerned, and I do want to state this to the committee, I am concerned that we received a letter from the Attorney General saying that he was going to come forward with recommendations. That never happened. The stakeholder group that was promised never happened. And when we went into the work session, he and his assistant showed up and were opposed to the bill and didn't have any recommendations which were promised. But beyond that, I do support this amendment, and when we're ready, I'll make a motion to that effect, but give an opportunity to hear for the parties that wanted to be recognized. Thank you.
Thank you, Representative Evangelos. I would note that Assistant Attorney General Don Maycomber is here, and we're going to hear from him in a minute. Oh, I'm sorry. Senator Bellows.
Thank you. I just wanted to share, I was a co-sponsor of this bill. I think the post-conviction review process is a vitally important civil liberty, and I think there is a significant amount of work that we can do in Maine to improve upon access to post-conviction review, and particularly in a time right now when we're looking at racial equity and the disproportionate incarceration of people of color. I think that this is a really important issue. I want to applaud Representative Evangelos and Walt McKee for working through an amendment that I think is a reasonable and a very important first step. But I hope that this is an issue that we continue to think about and work on, because I think that it's vitally important that we make sure that people who are innocent or who are wrongly convicted of a crime and wrongly incarcerated have that ability to access the post-conviction review process.
Thank you, Senator. Chair would recognize Representative Babbage. Your microphone.
Thank you, Mr. Chairman. Yes, I agree with Senator Bellows that I applaud the bill. I do become uneasy with regard to any legal use of the term innocent. And I see that in the bill, it is specifically defined, which I feel good about. But it does leave me with the question, what is the relevance of the threshold beyond a reasonable doubt in this case? In other words, if evidence is found that the major piece of evidence that may have caused a jury to find somebody guilty beyond a reasonable doubt is in fact in question because of new evidence. We don't have proof, or according to the definition that I see, that the person is innocent. So this is not designed to reverse a decision where the new evidence does not exonerate the defendant. Is that correct? In other words, I'm asking for the relevance of the threshold beyond a reasonable doubt here. The definition here does not reverse a finding based on evidence used in trial that was what's the word I want? Made less relevant or accurate because of new evidence. But the definition that you have here seems to say that if the person is indeed innocent, not just not guilty, but is indeed innocent, that this law would apply. Is that accurate?
That would be the way I read it. I'll go to Representative Evangelos in a minute, but I want to add a couple of questions for Mr. McKee when he comes on. The criminal justice system is not designed to prove innocence, it's designed to prove guilt. So I'm also troubled by the concept of innocence here. But I guess the other thing that would give me a little bit of concern was that there's no requirement here that any proof be offered. So anybody can make a claim that I have newly discovered evidence and file a motion for post-conviction review. What I would prefer to see, I might be able to go along with this, what I would prefer to see would be some offer of proof in the filing that this is the evidence that we've discovered. That would then give a court the ability to make an initial evaluation if in fact this is truly newly discovered evidence. But just the mere fact that you recite in your motion that you have newly discovered evidence, it doesn't, for me, it doesn't quite go far enough. And I have to leave briefly to go down and make a quorum for criminal justice. I'll be back. Representative Evangelos.
Thank you, Mr. Chair. I think what we're driving at here is when there's evidence that the incarcerated person will be entitled to a hearing. We're not making any statements beyond that. We're just allowing them to get into court to have the evidence heard. So I'm not sure. I'd like to hear from Mr. McKee.
Representative Clement.
Thank you, Madam Chair. I don't know. I support this bill and its amendment for the simple reason that I believe that neither justice nor the pursuit of justice should have an expiration date. And this bill remedies a current law that places an expiration date. And I find that untenable, particularly as the state, as Representative Evangelos mentioned, in cases such as homicide, can reopen cases at any time based on new evidence. I think that justice requires this bill as amended. Thank you.
Thank you. There's been a request to hear from Mr. McGee. So if you could unmute yourself, Attorney McGee, and if we could hear from you, please.
Thank you. Can everybody hear me okay? Great, thank you. So the amendment that was prepared was actually much more simple than a lot of what was being discussed. The original bill had a lot of components to it. And so the amendment, as you can see, really just deals with the deadline and it eliminates that deadline. And I think that's important and was important to the committee at the time that it was being discussed because of the view, as has been mentioned, that certainly for cold cases, homicides, that those cases can be brought at any time, regardless of the timing of the newly discovered evidence. The state could have found new evidence and decided for whatever reason they wanted to wait. Again, that's their business. But the bill was simple. It simply just said, look, if you're going to raise in a petition for post-conviction review that, hey, look, I got some new evidence, that you're not going to be barred by the 1-year deadline. And so, and that was the rub, if you will, was that deadline saying, well, it's, if you could have found it, you had a year basically to bring it forward. And this says that that deadline no longer applies. And that's why it became very simple in terms of a timing bill. It didn't deal with any of the substance. It just says, if the factual predicate of the claim is based on newly discovered evidence, so you're coming forward with specifically a newly discovered evidence thing, I've got this piece of evidence, that you're not going to be blocked outright from that. In fact, the post-conviction form as it is now, it actually asks, hey, you're claiming newly discovered evidence. When did you find out about that? And if you say in that form, well, I found out about it 2 years ago, then you're done. You won't even get that far at all. That question will be eliminated because it will say, is this based on newly discovered evidence? Check the box. And then procedurally what happens is it goes to the court. Judge considers it. Maybe it's a really significant piece of evidence that would have changed the result. But, maybe it also would have been something that was really small that nobody really cared about. And then folks can argue about those issues in court. The importance of this amendment was the timing alone wasn't going to block that process. The process was going to be allowed to go forward regardless of when that evidence was discovered. And it actually says that in the amendment. It says, regardless of when the newly discovered evidence could have been obtained or discovered through the exercise of due diligence. So this doesn't change anything other than give the opportunity for folks to bring their claims forward, regardless of the otherwise 1-year period of limitation. And I think the bill simplified that. And my impression was that that was what was generating some consensus, that the bill originally was far more broad. But this really struck at the core important issue that Representative Evangelist wanted to bring forward, and that's how the amendment was developed. Thank you.
Thank you, Mr. McKee. Could you just comment on Senator Carpenter's suggestion for a need of an offer of proof in the filing? Thank you.
So that's certainly a possibility. On the other hand, there's no other part of the post-conviction review process that requires that. So if you claim you just had a bad lawyer, separate from the newly discovered evidence, like they were asleep during the whole trial, you don't really have to do much more than indicate ineffective assistance of counsel. And so a single additional sentence of, hey, I found this new pen. This pen is important to the case. I guess you could add that. The problem is that understanding the importance of that is going to be something that a judge should decide after hearing all of the evidence and finding out and figuring out where this actually fits into the process. So instead of establishing a whole brand new process of a highly detailed analysis, your offer of proof and so on, the judge decides in the abstract, I would suggest that not be in there and that simply let a judge decide, just like the judge decides all of the other issues in a post-conviction review process without a detailed offer of proof.
Thank you. Senator Bellows?
Thank you. If we were to keep the language as drafted and proposed by Representative Evangelos, what I hear you saying is that would make it consistent with current post-conviction review processes rather than creating a new additional burden. I have a question. Would it also preserve or increase transparency to allow the defendant to come forward with the new evidence rather than having a preliminary determination by a judge?
So the answer is yes and yes. So this is a pretty simple part of the process. It really eliminates part of the form, which I actually looked at this morning, that would otherwise be a bar. It just basically says, if you say newly discovered evidence, just like everybody else, you get to go to the courthouse. And by the same token, it lays everything out on the table. And look, that's why we have judges. If they think it's worthless, then they're just going to take a look at it, and after hearing from both sides, dismiss it. It's as simple as that. So it's not all of a sudden these are all going to explode. No, they're going to be dealt with in context, and that's important to have that full context.
Representative Hagan?
I would like to hear from Mr. Maycomber.
My plan, Representative Hagan, was to get through all the questions for Mr. McKee and then move on to Mr. Maycomber. So we will get there.
Okay, thank you.
Thank you. Representative Babbage?
Yes, thank you. Thank you, Madam Chair. With regard to my earlier concern, I'm not sure we've really discussed that, but the bill itself, I think, does promote the interests of justice, and really the definition for actual innocence is only relevant at this point as a claim being brought forward. And it's fairly straightforward and narrow, if anything, which is what I would support. So I really am inclined to be enthusiastic about this bill. I will be interested to hear from Attorney Maycomber as to the consequences of passage, frequency of requests for review and so forth. So I'll defer and leave my comments there. Thank you.
Any other questions from committee members for Attorney McGee? Seeing none, there's been a request for AAG Maycomber. If you would join us, please.
Chairman Bailey, Senator Kime had her hand up.
And Attorney Maycomber, did you have any comments based on the conversation you've heard thus far?
I don't know if you want to take up Senator Kime's question first, because she did have her hand up in response to your last question as to whether she had any questions for Mr. McKee.
Sorry, Senator Kime, I missed you. Go ahead.
I don't think it actually matters to which of you I ask this to, but I was wondering, I'm wondering if you can help me understand how newly discovered evidence, how we put any parameters around that, because I can see this becoming cumbersome if we have to bring it to a judge for everything that is considered newly discovered evidence, even if it's pretty far-fetched. So that was my question, and so I guess whoever wants to answer it could be fine, if it's you or Mr. McKee.
I'm happy to, and I'm sure Dawn can as well. I think that the point here with the amendment is it's really just a timing issue. And so whatever's been happening with newly discovered evidence is something that a judge already decides now is it's within the parameters. So the parameters are, it can be anything, but it has the 1-year period of limitation. So in terms of the quality of that evidence, I don't think this bill addresses that, but I do think it simply addresses the time period limitation above beyond all else. In fact, that's all it does. So.
So just to clarify, it doesn't change what would be considered newly discovered evidence, but that's current practice, and so it just doesn't touch that.
Right, as far as I'm concerned, yeah, we did. That wasn't changed at all. Only the time use.
Great, thank you.
Mr. Maycomber, you want to respond?
Yeah, I agree with what Walt just said. My comments on the committee amendment is, first, our office takes no position on it, although from a personal level, I can say it's a significant improvement over the original bill from our perspective. In response to a question from Representative Babbage, I don't think it addresses actual innocence at all. It doesn't define actual innocence. In response to a question that Senator Carpenter had about a preliminary showing, I agree with what Walt said. I'm not sure if you were still in the room, Senator, or not, but there's no preliminary showing whatsoever here. All there has to be is an allegation of newly discovered evidence. My read on that is the law court has specifically identified what is meant by newly discovered evidence, and there's 5 prongs to it. And the way that I would interpret this amendment, it eliminates one of the 5 prongs, the due diligence requirement. But the remaining 4 prongs of the newly discovered evidence test would apply. The other, I guess, question I have, even though I think this is a significant improvement over the original bill, I'm trying to think of an instance where subsection C of section 1 would still be applicable, because I think I explained back in March that the way under current law, claims of newly discovered evidence are raised in post-conviction review is through subsection C. And I know the intent is to make it so that there's no due diligence requirement for newly discovered evidence, but then I'm trying to think, so when would subsection C apply at all? So I'm wondering whether subsection C of section 1 should be deleted totally and keep the Walt's amendment or Representative Evangelos's amendment. And one additional thing in response to Representative Babbage had a question about the impact of the changes and things like that. And obviously, if you're going to expand the universe of people that can raise these claims and eliminate deadlines, then there's going to be more people filing it. So that could present issues. And
Thank you.
The other question I had, just as a hypothetical, if there's no deadline, if someone finds evidence and then they wait years for whatever reason to bring a claim after, let's say, all the state's witnesses are dead or something like that, there's nothing that the state can do about it. I'm done talking unless anybody has any questions.
Thank you. Senator Bellows, you had your hand up.
Thank you. And thank you, Mr. Maycomber, for being with us today. I have a question about that, because I think that one of the things that we're discovering across the country is that evidence practices have changed. The power of DNA evidence and DNA analysis, for example, changed significantly as compared to what it was in the 90s or the 80s. And I guess for me, the question is, what recourse might someone, I mean, there are stories, again, from all over the country of people walking free after a decade or more of incarceration when DNA evidence identifies a different perpetrator and really makes it clear that the person who was incarcerated for the crime and even convicted was wrongly convicted and incarcerated. So absent, one of my concerns about the existing deadline under newly discovered evidence in Maine law is that it becomes a barrier, especially in an age of fast-moving technological innovation. So can you expound on how we address that absent Mr. McKee's pretty simple solution of changing the deadline? And I'm speaking here to the amendment because I understand that Representative Evangelos is asking us to consider the amendment, not his original bill at this time.
Right.
Mr. McCumber, you want to respond?
Sure. In terms of the DNA, there's a whole separate statute that deals with DNA evidence, and it has within it the ability to raise new DNA claims as DNA technology evolves. So long as you bring your claim within 2 years, my understanding of that statute is within 2 years of the applicability of the new technology. So this statute, in my mind, is really not so much geared to new DNA evidence. It's geared to other kinds of evidence. So like I can think of a witness comes forward from the original trial and says, I committed perjury at the trial. And I've had several cases like that where someone has come forward and said, I committed perjury at the original trial. And then you have to assess, once you get past the, if the claim is brought under current law, if the claim is brought within a year, then you have to assess, A, is the person telling the truth that they committed perjury? And B, even if they did commit perjury, how does that stack up against the other evidence and things like that? So in terms of DNA, I'm not sure if I've already answered your question in terms of the DNA. I don't want to keep going, but.
Thank you. Somebody else had their hand up.
Senator Bellows said.
Oops, sorry.
I just have a follow-up, Senator Carpenter, if that's in order.
Pardon?
I'll defer.
Follow-up if that's in order.
Go ahead, Senator Bellows.
Thank you for clarifying the DNA clarification. I guess to your point, I'm thinking about other types of evidence. You know, for example, we just recently had the posthumous pardon of Attorney Don Jellers, again, posthumously. Are there situations, you know, say that someone does recant because of perjury, or if they're, you know, someone uncovers, you know, someone uncovers files that had been shared with the defense, or something in an old box somewhere that changes or casts doubt on the original conviction. What recourse in those situations if they haven't met that time-sensitive deadline? And I don't know if Mr. McKee has some thoughts as well. I appreciate you making that distinction between DNA evidence in the statute and other newly discovered evidence, but I still have some concerns that sometimes there's new evidence that the facts have changed, that, you know, for example, leads us to posthumous pardons, which to me is a tragedy.
And my response, and obviously I'd like Walt to weigh in on it, if there is new evidence under current law, they can bring it so long as they bring it within a year. And I'm going to try and understand if someone has new evidence, why they would wait more than a year to bring it forward.
Representative Babbage.
Yes, thank you, Mr. Chairman. With regard to actual innocence, I just want to clarify that the claim requires a claim of actual innocence, but the burden of proof does not change. And so that issue is put to bed for me. But from what we've just heard, I do have the question, I suppose it's of Mr. Maycomber or Mr. McKee, to ask that, regarding a strategy to sit on evidence or whatever, should we have any concern that a key witness would be at risk with no timeline?
I don't
I'm
know.
sorry.
if that's-
Go ahead. Go ahead.
I didn't get the.
Who was your
Senator
question
Carpenter,
directed to?
who was the- yeah.
Senator Babbage?
Mr. Maycomber or Mr. McKee, at your discretion, Mr. Chairman.
Mr. McKee, you want to address that?
Yeah, I just didn't get the last part of the question.
Sometimes in a high-powered case, witnesses are protected, and my question would be: is the elimination of a deadline in any way does it put a key witness at risk? That's I'm exploring, thinking out loud here as far as consequences. And I was asking if history would lend itself to say that that's true.
I don't know that that's the case. I think that perhaps the more significant risk, if there is, that would be at or around the time of the original count. And so I'm not aware of any cases. I'll certainly defer to Dawn if he's aware of something happening at a later time that thereby made them at greater risk. If that's the case. I think that the concern that was brought up in terms of strategy, and I certainly appreciate and understand that, is it could be that it just took longer to develop one piece of evidence that leads to another piece of evidence. And why would anyone want to be precluded if some original evidence led to other pieces going forward just because it was older? And I think the reason that we keep coming back to this, what I do, was that is there some justification for waiting? I don't know. I don't know one way or the other. But I think if the idea here is to match what's being done in the cold cases, if the state decides to wait more than a year before bringing forward some evidence for whatever reason, there may be good reasons, there may be bad reasons. They should be questioned about, hey, why did you wait so long to bring this forward, or be eliminated from bringing your prosecution because they decided to wait more than a year. So I only keep returning to that because that was the idea behind this particular amendment. That's part of the answer to your question.
Thank you.
Mr. Maycomber, did you want to respond as well? And I'll come to Representative Evangelos.
Yeah, I mean, not to belabor what we talked about in March, but the difference from the state's perspective on the state can bring it at any time. Well, the state also is subject to motion to dismiss indictments for pre-indictment delay. And then, but if it's not dismissed, then they also have to convince 12 people beyond a reasonable doubt that the evidence that they have is of such a quality to convict the person. Whereas in a post-conviction review case, all the defendant has to do is convince one person, the judge, by a preponderance of the evidence, that their evidence means that they shouldn't have been convicted. But in terms of the Representative Babbage's question about risk to witnesses, Dennis DeShane is a perfect example of this. This is before there was a one-year statute of limitations, where Dennis DeShane is convicted in 1988 of murder. He waits 5 years and files his first state post-conviction review, claiming essentially actual innocence. And his original trial lawyer, to whom he confessed, had a stroke. And so we were kind of stuck with that, where we had evidence that DeShane was guilty. Well, the jury found him guilty, but to defeat his actual innocence claim. But because his original trial lawyer had a stroke, we couldn't call that witness, call him as a witness at the post-conviction hearing. So the more time goes by, then the harder it is for the state, assuming that a case gets reversed.
And to some degree, that goes to the question that I asked before I left, and I'm sorry, and I don't know if anybody answered or not, but if 10 years has gone by and now you have a new judge who has to go, so the petition will be presented to the court, the presiding justice is long gone, and without any representation of what the newly discovered evidence is, the new judge to whom you're presenting your petition is going to have to go back, I guess, and review the entire transcript and review certainly all of the evidence, the trial evidence, to see if this is truly newly discovered or was it already discussed at trial. I mean, I still am, I'm a little bit hung up on the idea that there should be at least some sort of an offer of proof of what the evidence is. Representative Bailey, I'm sorry, Representative Evangelos, and then Representative Bailey. Those will come after Representative Evangelos.
Okay, thank you, Mr. Chair. I want to go back to where we were at the work session previously. I know that Chair Bailey and I believe it was Representative Records both raised the issue of, you're sitting in the state prison in Warren. You've got very, very limited communication, and you overlay that with the findings of the Sixth Amendment Center report. It's not unreasonable to posit that getting everything you need to get done within 1 year is an easy task. And in fact, in the Bates case, Justice Cole ruled against his motion for a post-conviction hearing because he said he found it hard to believe that even if Bates didn't know, that his lawyer should have known that he had to bring the new evidence forward within 1 year. The lawyer actually brought it forward on the 364th day, but the judge still made an issue of it and ruled against Bates. So I don't think it's unreasonable if you've been to the prison and seen the conditions and the lack of communications, the way the phone system works, and the evidence of, on occasion, ineffective legal counsel that has been provided these people, that a year could go by and you'd miss your chance. And I don't think it speaks to justice to allow having an innocent person sitting, incarcerated when there's evidence out there that would clear them no more than we want to prevent evidence to come forward to find and convict somebody on a cold case homicide. I think we just need to level the playing field a little bit here. Mr. McKee's come forward and helped me with a very modest amendment, and it does address this due diligence standard. We don't want people sitting in prison because their lawyer did a lousy job. If there's evidence that can come forward because the first lawyer didn't proffer the evidence appropriately, we want justice in the end. And that's the whole intent of this bill.
Thank you, Senator Bellows.
Was Representative Bailey going to be first, or I can wait if that's no, okay.
No, go ahead.
I don't want to make this, just to amplify what Representative Evangelos was saying, I don't want to make this a referendum on any one particular person. I think that's problematic. I do think it's really important that the tools for the prosecution and the defense in our criminal justice system are aligned. And in the same way that we can return to cold cases many years later, and absolutely should, so that there is justice is served when we return and take a second look if there are any questions that someone is wrongfully incarcerated. So I just wanted to make that point because I think it's really important that this not be a referendum on any one person. And certainly there is a significant debate. Books have been written about irregularities in the Dennis DeShane case. I don't think we should be thinking about a single individual. We should be thinking about how we're improving the system.
Thank you. Representative Bailey?
Thank you, Mr. Chair. Mr. McKee, I was just wondering your thoughts on Mr. Maycomber's comment that if we pass this as amended, that do we really need Section C anymore? Can you envision a scenario where Section C would be applicable? So I would just like your thoughts on that. Thank you.
No, it's a very fair comment. I don't think, in light of the amendment, that it's necessary. And of course, there's the clarifying part where it says except when subsection 1A applies, which basically eliminates that portion. So if you eliminated C, that would not change anything as far as I'm concerned.
My question to Mr. McKee also, I'll come to Representative Cardone in a minute. While I was out of the room, did you address the issue that there need to be a showing or an offer of proof or something as to what the newly discovered evidence is?
Yeah, I believe I did. As it stands now, you don't have to do that for your claims. For any of them, you can make and that could be a whole, that's all of the claims, not just newly discovered evidence. If you're claiming that your lawyer did a bad job generally, not newly discovered evidence, then you don't have to provide, any more than basic information. As a practical matter, what often happens is that the petition is filed often by the pro se defendant, an attorney is appointed, and there's a process that judges and the prosecutors and the defense go through to flesh that part out. And so my experience has been there's a lot more detail that's provided, although not on the initial petition, but as part of a more detailed process that takes many months, so the defense can give better notice to the state about really what they're talking about, as opposed to, I had a terrible lawyer. So our view is that having some additional preliminary showing, just because it was over the 1 year, if it was a couple of years or 3 years, really wouldn't advance the process that much more. I understand and appreciate that, but I think it's creating another process when the better process may well be to simply give it to the court to make that decision, what they do.
I agree with the premise of everybody's questions here that nobody wants anybody to stay in jail one day if they're not guilty of the crime. And that's what the criminal justice system is supposed to be striving for at every case, every trial. However, I'm still troubled by, we're 5 years down the road, let's say, and we have a new lawyer, we have a new judge, the old judge is no longer on the bench, probably have a new attorney. I appreciate the fact that I'm sure once somebody goes to prison for some serious crime that there's such a shock that it will take them, going to Representative Evangelos' point, it takes them a while to get their feet under them and maybe find a new attorney if their attorney wasn't competent and all of that. So I agree generally that we should expand the time within which this can come. I just don't want the courts flooded with frivolous actions where there may in fact be no newly discovered evidence. Those are the key words here. This is new evidence or newly discovered evidence. And I still think there needs to be some sort of a showing at the courthouse door. So, okay, Representative Cardone has her hand up.
I have two things. Just first of all, as a practical matter, I'm having a difficult time hearing back here. Senator Carpenter, I can hear you fine. Representative Bailey, I didn't hear one word you said in your last speech. Representative Evangelos, I probably get 25% of what you're saying. So I just want you to be aware of that. As to the bill in front of us, I guess I'm struggling with the same things that Senator Carpenter is struggling with. And Senator Carpenter, you have much more experience than I do in criminal law. Can you fix for me the nexus between what you're saying and some sort of showing and this imposition of a 5-year time period or the elimination of the time period altogether. I'm not sure I understand that. And again, maybe it's just because I'm not hearing well what people are saying.
Welcome to my world. Every day, as far as the hearing part. I appreciate that, Representative Cardone. And I wasn't looking to impose a 5-year limit. I was, if we're going, my point is this, if we're going to eliminate, in the interest of justice, the time for filing a petition for post-conviction review, I'm sort of throwing the burden on the new attorney who's bringing the action to say that person should come before the court. It's like the showing of a substantial change of circumstance in a family law matter, okay? That you make a representation that here's the evidence that we've discovered. Not that you don't have to do the due diligence piece. You say, this is the new evidence that we have, which was not considered by the trial court at the time of the trial. Rather than just make a base kind of bare bones representation that we have newly discovered evidence. That's all I'm asking for, is to say, okay, we have 2 witnesses who have now come forward in the interim 6 years or whatever period of time that's passed after the conviction. We have 2 witnesses who have come forward who have material testimony to provide that go to the issue of the actual innocence of John Jones. That's all I'm asking for. I don't think it's a huge burden, but let's make the attorney who's bringing the action make a showing that he or she has some evidence. That's all I'm asking for. Just to follow up on that, if you don't make that showing, then you get in the courthouse door by the bare bones representation. And I'm not sure, at some point, the new justice is going to have to go review all the evidence from 10 years ago, or 15 years ago, or 20 years ago, to see what was considered. I mean, this is potentially putting a significant burden on the court, and I just want to make sure we do it thoughtfully. They're going to have to know at some point, they have to know what the new evidence about to be presented is. And then they have to go look and see, well, that was considered. The trial justice in 1996 ruled that evidence was not admissible. That's all I'm saying, is let's try to sort that out before we burden the courts too much here, because there will be a number of claims, in my opinion. Senator Kine.
I'm not sure if I'm supposed to use the raise hand function in Zoom or just simply raise my hand. So I've done both, and if there's a preferred way, you can let me know. I agree with what you're saying, Senator Carpenter, but that was kind of why I asked whether there was any parameters around newly discovered evidence currently in law, and I guess there isn't. And so then my concern is that we dive into, because I'm also concerned that we overload the courts with, with frivolous, suits like this. But I wonder if it would be better to change the time limit rather than change the process of newly discovered evidence. I just don't see a clear way forward for someone to say, well, this newly discovered evidence is valuable and this isn't. Like, who decides that? And the person that decides that, are they unbiased? If it isn't the courts.
Thank you. I want to go back to Representative Cardone. Did I answer your question?
Yes, you did.
Thank you. So Senator Kime has raised an issue, and I know that Mr. McKee had his hand up back when I was going on. Mr. McKee, do you want to respond to my comments, or Senator Kime?
Yeah, yes, I do. So in the hypothetical that you'd posed, I think that that actually is a situation that we're already dealing with right now. So let's say that there was a conviction from 10 years ago. Judge may be, gone, lawyers may be gone, but the new lawyer discovers new evidence, and upon discovery, within 1 year, the day after they do that, they present a post-conviction review to the court. Well, the court actually has to do exactly now, as the law is, to go back through and do that analysis. And so I'm just suggesting that that process is already happening now, and something that we've acknowledged, and that we use in the post-conviction review process when there's newly discovered evidence. So to changing the bill to add that piece in there, some additional component, is not going to really change what we already have right now. And I guess the other piece is that if the evidence is not really new, like if it was like, look, that you're talking about the same knife that was already admitted in the original trial, well, that's something that the state can simply move to dismiss based on. I mean, that should be fairly simple and straightforward. So I appreciate your concerns about having some sort of initial showing, but I guess the other concern is that just is putting up another roadblock. But I understand the position.
Mr. Maycomber, did you want to weigh in? You're muted. I didn't do that to you. There we go. Go ahead.
I agree with Walt that currently under law, there's no preliminary showing. All there has to be is an allegation of new evidence. So, and the current bill does not, the committee amendment before you doesn't require any preliminary showing.
Right, I understand that. And the reason I keep bringing this up is because now we're looking at potentially down the road X number of years.
Right.
Okay. Other persons, other members of the committee that have questions or comments or concerns? If not, Representative Babbage, go ahead.
Hold on. Yes, thank you. If I can remember what my question is now. May I ask what percentage of reviews are granted given the current process? And of course, that would also, that decision would be made by the presiding judge if still active on the first trial. Is that correct?
Well, it
yes,
wouldn't necessarily be made by the presiding judge. It would be made by a judge. Go ahead, Mr. McCumber.
Thank you, Senator. I hope said Your Honor. Under current law, post-conviction reviews are assigned to the original trial judge, assuming the trial judge is still available. And can you remind me?
I was asking.
How many are granted?
How many and how many are granted? Yes.
Yeah, it's extremely rare. So when, not to be flip, but when Senator Carpenter says he's concerned about the courts being flooded with frivolous petitions, well, it's been my perspective that most of these are frivolous, or at least don't end up being granted. I'd say, in my experience, like maybe one every 10 years gets granted.
Well, the reason I asked that question is I'm wondering if, following Senator Carpenter's original suggestion of being more specific with definition of new evidence, that may in fact be an advantage to a defendant, given the fact that current reviews are being denied at such a rate.
Thank you, Representative Babbage. Representative Harnett.
Thank you, Mr. Chair. And this is a question for both Don and Mr. McKee. Is Maine's statute and putting the time limit on the review of newly discovered evidence common throughout the states? And in states that don't have deadlines, do you have any knowledge as to whether or not courts are flooded with these types of cases? I mean, we keep hearing that the courts are going to be flooded. And I'm wondering what the experience is in other states.
I don't know what the other states do.
And I don't either. I'm sorry. I wish I had answered that better, but I don't know either.
Senator Bellows, did you have a question?
I don't have a question, I have a comment, so I can wait until the
Okay.
questions are thoroughly explored. So thank you.
Thank you. Other members of the committee that have questions or need clarification on any of this? Go ahead, Senator Bellows, your comment.
So I appreciate the efforts to try to get to a compromise, but one of the things that I think is really important about the amendment that Representative Evangelos has put forward, and that was instrumental in drafting, is its simplicity and not creating overly burdensome new definitions or complications in the process. I think it's really important to keep grounded in the fact that our criminal justice system is supposed to be grounded in the values of due process outlined in the Constitution. And one of my concerns about our existing post-conviction review processes, and this goes to Representative Harnat's question, is that deadlines create procedural burdens that eliminate people's ability to bring valid evidence. And I am deeply concerned, the work of the Innocence Project, for example, nationally, has demonstrated that mistakes do happen. And to know that there are people serving time in prison for things that they didn't do. I mean, to go back to Senator Carpenter, something you said earlier, that is our goal. And I don't think, given the courts, I think Representative Evangelos's amendment is a first step. So I'm inclined to support that as presented because of its simplicity.
Other questions from the committee? If not, I would request Senator Bellows and Representative Babbage to begin their way to the chamber.
Can I just make a couple of clarifications before you go?
Sure.
I mean, I think you're talking about eliminating paragraph C, which makes sense to me. I didn't know if it was covering anything else, so I was reluctant to take it out. But if it's not covering anything else, then definitely repeal paragraph C. And then you also ought to change the title of the bill, because the original bill talked about actual innocence. We should take that out of the title, because I think that's confusing the issue. Nobody is making a claim of actual innocence. What they're doing is claiming they have newly discovered evidence that they want taken up. So those are two things. If you're
right.
While I have you listening to me.
Yeah, the pending motion is reconsideration. Once Senator Keim, I'm sorry, you've already reconsidered?
No, we never voted on this.
Oh, we never
Never
go. I'm
voted.
sorry. I apologize. I thought, all right, so let me go to Senator Keim.
Thank you. My question was, so once we vote this, then we'll send this to get a fiscal note. Is that right? Thank you.
Sorry, repeat that question, please.
Once we vote this, then we'll send it to get a fiscal note. And I saw Peggy shaking her head yes, because I imagine there will be a fiscal note on this. Thank you.
Senator Bellows, you have a question?
And is, Peggy, when you say eliminate paragraph C, do you mean in the amendment that Representative Evangelos circulated via you on Monday, you mean the language that says except in subsection 1A, or do you mean the entire? Yeah.
I mean the entire thing. So all that would be left in subsection 1 is paragraph A and paragraph B, because both Mr. McKee and Mr. Maycomber said really the only thing that paragraph C addresses is newly discovered evidence.
Oh, okay.
If that's true, there's no reason to keep C there.
Okay.
Because newly discovered and evidence will be in subsection 1A. That's that.
Okay, great. Yeah. Now I
Senator Bellows and Representative Babbage, if you would make your way our direction, please. We'll pause the proceedings until they arrive. And so technically, I don't think we're supposed to vote on an amendment until we have it in front of us. Do what? I can't. All right, we're going to take a 10-minute pause while I run back to criminal justice. Sorry.
I've got the Judge Cole's observation decision here.
I would call the committee back to order, please. Mr. McKee, are you still with us? Mr. McKee, are you still with us?
I am.
Mr. Maycomber. So what we have discussed amongst us informally while we were off camera at the suggestion of Representative Bailey would be an additional piece to the amendment, which would give the assigned judge the discretion to ask for a fleshing out of the pleadings, if you will. The judge could ask for, prior to hearing, the judge would be given the authority to ask for, again, my words were offer of proof. Your thoughts, Mr. McKee?
Just to get a better understanding that this would be specific to newly discovered evidence that would be after 1 year for this particular, that window from 1 year to whenever.
The amendment that Representative Evangelos is proposing would stay as is. We would eliminate section C, but on his amendment, we would give the court authority to request, not purely discretionary, to request a showing by the petitioner of the evidence, or an offer of proof as to the evidence. Permissive, purely permissive.
Yeah, and
what we're trying to get to here was to try to help the judge, assuming, and I'm assuming others aren't, that we might have a new judge here, trying to get the judge to a point where he or she can make a more informed decision at hearing. If they think they need more information than just the bare bones pleadings of newly discovered evidence, then they may ask for a fleshing out of that.
So on that score, depending on how it's worded, I wouldn't have a problem with it to the extent that they allow the court the discretion to ask for additional information.
Right.
I guess the part that I'm stumbling on is maybe because you used the term offer of proof. So I wouldn't want that to thereby then be a barrier to go in. So if the judge says, look, you said newly discovered evidence, could you just tell me a little more about it? And then we'll have a hearing about it later on. I don't think that's unreasonable.
Representative Cardone has her hand up, but I want to go to Mr. Maycomber first, then I'll come to Representative Cardone. Go ahead. Donald, your thoughts?
I don't see a problem with doing that. I do know that the rules governing post-conviction, the court rules governing post-conviction, allow the assigned justice or presiding justice to ask for affidavits, but that's not so much in the manner of like a preview of the evidence. So,
okay, so I anticipate what this would say would be the assigned justice could require the petitioner to make a showing of the evidence, of the nature of the evidence. I'll put it that way. Okay. Okay. Representative, Representative Evangelos, you understand what I'm saying? I'm trying to figure out the right words. So could require the petitioner to make a showing as to the nature of the newly discovered evidence. Representative Cardone.
Back to Mr. McKee's point, yeah, the offer of proof might be too formal a term. We were just looking for the court to be able to request a more particular statement or a more description, something more specific on the nature of the evidence, not necessarily in affidavit form or in sworn form, but something more than just, I have new evidence. If the court feels that that would be helpful. And we were thinking of this, I think, more in terms of judicial economy, allowing a judge to zero in on what he or she might need to do to prepare for a hearing, especially if this wasn't the trial judge. And in the case of a pro se petitioner, to allow the court to be sure, allow the judge to be sure that he or she has enough information to frame the issues, because the issues are not likely to be well framed. And again, if we're talking about a potential exoneration of somebody here, it's important that a judge be able to use what time he or she has to frame those issues. I think that was really the nature of what we were talking about, not whether or not something was signed or sworn or put into a specific format, but that the judge had more details if the judge felt that those details were needed.
Yeah, so I guess the language would be you could basically add on to 1A with respect to claims based on newly discovered evidence. The court has the discretion to request additional information that the court would find helpful in.
Let's just say may require. I'm sure Peggy has language already drafted.
Sorry.
As we've been blathering on here.
Sorry.
Thank you for helping though. Peggy, what do you got?
Oh, I was telling Walt to keep talking because I liked what he was saying. Right. I mean, I don't know how specific you want it, but I actually thought what Mr. McKee was saying was making sense.
I would just say may require rather than has the discretion to.
Yep.
Perhaps may require. Who had a question? Representative Babbage.
Thank you, Mr. Chairman. I just wanted to ask what, should we adopt this, which I tend to be in favor of, what impact would it have for an action that does happen within the first year? And what is in the best interests of the defendant in that case?
I don't know.
I don't know if you want to create two standards of the first year as opposed to the forever. Then you probably need to do a major rewrite, or not a major rewrite, but to address that. Seems to me if we're just going to eliminate the year, then probably this additional language. I mean, I'm not sure we should have different levels of whether the court has the discretion or may or whatever, whether it's 1 year, 5 years, or forever years. Maybe Mr. Maycomber agrees with me on that, and having different standards may not really advance the discussion.
I agree with that.
And if I may, my question, I was actually thinking of putting a burden on the defendant in the case, but actually the way we're doing this is we're giving the court discretion, so maybe that's not relevant. So the 1 year period can be eliminated altogether, which is good.
Back to Peggy, who's hiding in there somewhere. There you are.
So it sounds like you want to say something like the court may require the petitioner to provide additional information about the nature of the newly discovered evidence. Is that what you're looking for?
They want me downstairs?
No.
Oh.
Senator Bellows isn't on Zoom and her hand's up. So
Okay, gotcha. Senator Bellows.
Thank you, Mr. Chairman. I just have a process question because I'm open to compromise, but I think this is exceedingly important precedent that we're setting from a civil liberties perspective. So my process question is, I know we're trying to be as efficient as possible given the limited time that we have, but would it be possible to allow Peggy to draft, circulate, table this today, but come back next Friday in hopes that would be the motion before us, recognizing that time would allow us to process what are the potential precedents that we're setting.
I'm fine with that. I mean, we're not going to have a lot of time, but I think we've We've discussed this.
Yeah, we've discussed
We're not
the
going to have,
issue
we're not
pretty,
going to,
yeah.
any more discussion time later on. So any other questions as to what it is we're asking Peggy to do? And if not, then I'm going to look for somebody to give me a motion to table. Moved by Representative Evangelos, seconded by Representative Harnett. Show of hands, all in favor of tabling? Thank you. All opposed? One. Okay. Matter is tabled. Thank you, folks. I don't know whether some of you are hanging around for the rest of the fun or not, but if not, thank you very much on that. Next, we're going to do LD 1061, an act to establish a fund to compensate unjustly incarcerated persons. Another Representative Evangelos bill. LD 1061.
Right, I had taken the amendment that Representative Evangelos had provided at the public hearing, and we had talked it. You had talked about it in committee. You had tabled it. You have not taken a vote, and you should have an amendment in your packet that is several pages long, partly because it includes some of the language from the bill that has been struck out. But it does create a new chapter about compensating unjustly incarcerated persons. We do have a law on the books right now. It's totally tied to a pardon based on innocence. And there have never been any payments.
Peggy, could you hold just a minute? I broke my rule. I believe Senator Bellows and Representative Babbage are en route. So I had promised them I would not discuss matters while they were en route.
That was probably my mistake.
No.
Just jumped in.
I'm waiting to see Senator Bellows under the watchful gaze of President Lincoln.
Thank you. 1061, that's all right.
There she is. All right, Peggy, I'm sorry. Could I ask you to repeat that, please?
No problem. So we're looking at LD 1061. This is a bill you have not voted. It is Representative Evangelos' bill. He actually presented an amendment at the time of the public hearing that made significant changes to the bill. And that's pretty much what this is, what this committee amendment is. It is more in the format of what you're used to looking at. The current law does provide for a small compensation payment if you have a pardon based on innocence. We have no history of any money ever being paid out of that current system. This new program would repeal the current law and establish a new compensation fund and provide a completely different standard for going forward with any kind of compensation. The person would be entitled to compensation if they've served any part of a sentence and they've established by a preponderance of the evidence that the person was convicted and subsequently imprisoned for an A, B, or C crime or murder. The conviction was reversed or vacated, and either the charges were dismissed or on retrial, the claimant was found not guilty. The claimant did not commit the crime and did not commit or suborn perjury, fabricate evidence, or by the person's own conduct or bring about the conviction. And then there's the process here, and the payment would be, that's on the top of page 5, equal to $50,000 a year for each year of imprisonment. And if they were required to register on the registered sex offender registry, it would be $10,000 per year for each year that they were required to be registered. the process is the district court would determine the eligibility of the claimant and the amount of the compensation. That it would be a claim filed with the district court. And that is who would be making the decision. But it would just, if the person met the requirements in the statute, then they would be eligible for the compensation. I think, I mean, we can talk about more of the details, but that's the basic, unless Representative Evangelos, his bill, he's been the one working on it, so I don't want to cut him off by any means.
Thank you. Representative Evangelos.
Thank you, Mr. Chair. Can you hear me, Barbara? The amendment that Peggy's written has captured the spirit of what I was after. Senator Carpenter had raised the issue of the irony of having gone through all this process and then you still had to find and get a pardon. So the pardon portion has been taken out. And I think the old law required you to have to file a lawsuit in Superior Court. Did it not, Peggy?
It was a strange process. It was probably no wonder why it was never used.
Yep. So I think this is a big improvement, and I don't have any further suggestions from what she's drafted. I'm happy with it. Look forward to hearing what others might think.
What is the fiscal note?
We have not submitted it for a fiscal review.
Okay, gotcha. Representative Bailey.
Thank you, Senator Carpenter. And Barbara, can you hear me now? Okay, yeah, it's really the math. So I just have two questions, either for Peggy or for Representative Evangelos. The first is on page 2, section 3, and that's the part that talks about if the person entitled to compensation is deceased. It says the person's heirs, legal representatives in a state are entitled to lump sum compensation. I'm just not sure what that means with the "and" in there. And yeah, I don't know what that means. I mean, I think I understand the intent is to make sure perhaps that the estate receives it and then it gets distributed, but the language of the heirs, legal representatives, and estate, that's confusing to me. And then another just quick explanation piece is on page 4, section 5. This is the right to appeal. And it just says the claimant may appeal a claim that is denied. I assume that means to the Supreme Judicial Court, but should we clarify that that's the intent? Those are my two questions. Thank you.
Anybody want to respond?
Evangelos has his hand up.
Oh, he does? Representative, I see, there you go. Representative Evangelos.
Thank you, Mr. Chair. I think in reference to the deceased persons, if we put an "or" in there rather than an "and", would that help?
Thank you. I think it would still be unclear to me that if there was an award of $200,000, how you're going to separate that out between those different groups. I mean, typically, if something goes to the estate, then it flows through to the person's heirs or devisees. So I think if you just put estate, that's probably your intent. I'm not sure what you're trying to get at in terms of differentiating between estate, heirs, and legal representatives.
So I think this language originally came from the Innocence Project or somebody working with the Innocence Project. And maybe that was more choice per state. And so it sounds like what you want to change, you would recommend Representative Bailey to change it to would be the person's estate is entitled to lump sum compensation.
Representative Evangelos.
Yeah, that'd be fine with me, thank you. That would be fine with me, thank you.
Other questions or comments?
Yes.
Representative Babich?
Yes, thank you. I have a question regarding the threshold. In B on page 2, it does say a person has established by a preponderance of the evidence. I do notice that 9 states have a $50,000 amount of restitution, and that 7 have more than that and the rest less. But does anybody know if a preponderance of the evidence is the usual threshold for those claims?
Peggy, do you know?
I do not know.
Do we know where that specific language came from? And I just wondered if we're making the bar easier, or is it consistent?
Representative Evangelos, do you know the answer?
I don't know the answer specifically to that, but I think paragraph B2, the conviction was reversed or vacated, and either the charges were dismissed or on retrial, the claimant was found not guilty, is the clarification that I was looking for.
Somebody else had their hand up, but I don't know who it was. Representative, I'm sorry, Representative Cardone?
Couple of things. On the standard of evidence, I have no specific knowledge of anything, but I don't see why we would make it more difficult than a preponderance of the evidence. This is a case that I would think have the normal civil standard. I don't see why it would have any heightened standard. If anybody else has a thought on that, I'd be happy to hear it, but it seems to me that preponderance of the evidence is appropriate. My other question.
May I ask, Barbara, preponderance is the civil standard?
Right.
Yeah.
Thank you.
Well, that's usually what you would have a civil case judged by, is preponderance of the evidence. So I don't see any reason to set the bar higher for someone seeking a claim under this. If somebody else does, I'd be interested in hearing it, but there's nothing that strikes me.
Thank you.
I have a kind of an odd question. I'm looking at my folder, and on the inside of my folder for this case, in writing that is not mine, it says ought not to pass 9-0 with 4 abstentions. I'm putting that down maybe to something that Soupy had done and she's recycling my file folder, or did we have a vote on a prior rendition of this amendment? I remember no vote on this, and I'm just wondering if my memory's checked out.
I think you got it right the first time. Soupy recycles all the files.
Oh, okay.
So
I'll just put a line through it and ignore it.
Other persons who wish to weigh in? Maybe I missed a hand. Wave your hand at me if you want to talk. What? Okay. Representative who? Oh. David, Representative Hagan, go ahead. Senator Bellows, you're next.
Chair, that amount of money, the 50,000, seems excessive to me, and I seem to have a problem with it. I thought that originally it was 25,000, and that seemed very reasonable to me. But the 50 seems excessive, as jobs in Maine are hard to come by at that number. So that's not really a question. It's just a comment, I guess, that I have.
Thank you. Senator Bellows, you had a...
So I guess I have a question and a comment. And again, it's a little bit, the first question is substantive. The second comment is process oriented. This is something that I am a supporter of completely in principle. And I think that prior to the pandemic, I would have been eager to vote ought to pass. I'm increasingly concerned about future revenue shortfalls. And when I look at the large number of bills in the Appropriations Committee, I think it's really important that we prioritize urgent needs. And so one of the pieces of testimony was we don't have any cases at this point in time. This is something to do as a best practice for the future. And so I have two questions. One, is the proposal on the table from Representative Evangelos, and this is a question for him, to endorse the policy and let the process and appropriations weigh through the revenue priorities? And two, and this is a question for the attorneys in the call, and that is, if somebody were released today and found to have served, 20 years for a crime they did not commit, could they petition or sue the state for an award of compensation for unjust incarceration at this point in time? Or are they just completely out of luck in Maine because of the absence of a statute like this or a fund like this?
Peggy, I'll turn to Peggy for that one.
I'm not sure. I'm pulling out the existing law to see if that says that's the only remedy. I guess you would have to overcome the Tort Claims Act. If the Maine Tort Claims Act would provide immunity to the state under the, as it exists now, then you could sue, but you're not getting very far. The existing law waives the Tort Claims Act. Just thinking, do we do that in here? We have to make sure we do that.
Representative Harnett.
Thank you, Mr. Chair. I just want to respond to Representative Hagan's questions or comments about the amount. I don't think we should be comparing this to what an average employee makes in the state of Maine. I know if I were presented with the option of going to jail for a year and being paid $25,000, I would say no. If I were presented with the option of going to jail for a year and being paid $50,000, I would still say no. This is about compensating somebody for a total and complete deprivation of liberty for charges that they were ultimately found to be not guilty of. I think the numbers are appropriate, given the fact that we have not had any cases like this. I don't see this as being a potential serious drain on the general fund. So I would support it at the $50,000 number, remembering that we're talking about a year of somebody's life, not lost earnings.
Thank you. Other Representative Evangelos.
Thank you, Mr. Chair. I forgot who asked the question now, but I think the current law requires you to go to Superior Court and limits the judgment to $300,000. Isn't that correct, Peggy?
A lot of head nodding here. I think that's accurate. Other.
And secondly, I just would concur with Representative Harnett. I remember when Anthony Sandborn appeared before us, he explained the fact that he missed out on his children growing up and all kinds of other opportunities besides the opportunity to hold a job. So it's hard to put a price on it.
Thank you. Other questions, comments? Oh, Representative Babbage.
Thank you, Mr. Chairman. may I get a clarification on retroactivity from what Peggy said? I mean, immunity of the state, which I'm not clear on actually either, given the fact that we have this $300,000 cap. But I guess when I'm looking at anticipated fiscal note here, retroactivity would have a huge impact on that. And I'd be interested to know if this is retroactive. In other words, does this apply, even though tort law, you know, to my understanding, I thought was immune from lawsuit. The state was immune from lawsuit. I may be wrong about that. I'll clarify me, please. But what I'm asking is, can we anticipate a request for justice for past wrongs as part of the fiscal consideration of this bill, or is this going forward?
I believe this would be prospective only.
Thank you.
Other questions? Are we ready for a motion? Do we have a motion? Okay. I'm going to need to go, but if there's more comment or questions, that's okay. If not, I'll look for a motion. Representative Evangelos.
I'll make a motion not to pass as amended.
Motion on the floor is ought to pass as amended. Do I have a second for that? Representative Barnett? Any further discussion? Representative Bailey?
I just wanted to clarify that the amendment includes that change to just changing it to a state in that one section.
Yes, in that paragraph, you clarified. And also on the appeal paragraph, did we want to say appeal to the Supreme Court? So that the ought to pass as amended would include those two changes.
I'll sit here for a minute and then. Representative Babbage? Did you have?
No.
You going to join us?
Oh, yes, I do.
On your horse.
Thank you.
So after this vote is cast, we're going to break until 1 o'clock. I'm sorry? I did. I'm going to vote here and I'm going right down. Yep. I get paid for 2 days. All right, let me call the committee back to order. Oh, we're waiting for Ms. Simino. One moment. Yeah, I should have brought something for lunch, but I didn't. committee back to order. Pending motion on the floor is ought to pass as amended. We're going to take the appeal to the Supreme Court. We are going to change the word to estate. Everybody clear on what we're voting on? Okay. Go ahead, Ms. Simoneau, and call the roll, please. Yes.
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 Thank you. The folks who are remote have 24 hours, please, to contact us. And now keep in mind that the Senate President and the Speaker offices won't be open tomorrow, so you probably will have to do it today or by email. At this point, we're going to take a break until 1 p.m.
Okay. What did you just say, Peg? Oh, thank you. Okay.
We're waiting for the rest of the committee folks to come back. We say 1 o'clock, that's Judiciary Committee Standard Time.
Senator Carpenter, do you need a quorum in the room or do we already have an existing quorum?
I think we're in recess, weren't we? Something.
I believe we're all set, Senator Bellows. They were sitting in there, but they knew to come down. I don't know where Jeff is.
I know I'm not with the committee, but I think I'm in a time warp here. The clock says 20 minutes of 9.
Don't look at the calendar. How are things down your way in southern York County?
Very good, very good. The roads are not as busy and the tourists are not in large numbers, however. Right. Which, you know, gives mixed reaction depending on who you're talking to.
Yeah, I know. Bar Harbor is quite quiet.
Saying to Chris, I know where all his York County people are from out of state. They're all in Portland. Clogging up. A lot of Massachusetts, New Jersey, New York cars. A lot of Massachusetts.
Senator Keim, are you with us? Representative Hagan, are you with us? Anybody else not in the room with us?
Hagan, I'm in.
Okay, hi David. Okay. All right, we're gonna resume our work by taking up LD 531, an act to provide counsel for a person who's subject to adult guardianship, conservatorship, or other protective arrangement proceeding. Representative Cardone's bill. Peggy, you're on.
Thank you. So at the last work session, you folks had talked about this. So the original bill required the appointment of counsel in all cases for adult guardianship and adult conservatorship unless they're already represented. The current law says that the court shall appoint an attorney for respondent, for basically in these cases, guardianship, conservatorship cases, if an attorney is requested by the respondent, recommended by the visitor, the court determines that the respondent needs representation, or it comes to the court's attention that the respondent wishes to contest any aspect of the proceeding or to limit the powers of the guardian, or would be limit the powers of a conservator. The purpose, you asked me to go back and draft language that created a presumption of appointing representation that could be rebutted if the court finds by clear and convincing evidence that basically the adult either doesn't want to be represented by an attorney and does so voluntarily and knowingly. And so if they already had representation, then the court wouldn't be appointing an attorney. Attorneys that are appointed by the probate court are paid for by the counties. That's a county expense. And so you asked me to send out whatever language I had to the probate judges and the probate registers. And I did that. I sent it to Kathy Ayers, who's on this call, and I sent it to Judge Libby Mitchell, and Judge Mitchell sent it to all the other probate court judges. And so if you have your packet, and it's what I emailed to you too, the amendment is 2 pages with a little bit more for the summary. And then after that is the comments back from the probate judges. They generally don't think this is necessary. And I think they're also worried about some of the costs that the county might incur. The testimony was that what the current law provides, when a judge is required to appoint counsel, it really covers all the cases where a counsel is necessary. And the judges are very good at looking at who needs, who meets this criteria, and they will appoint an attorney. So the question is, who, I think if you go along with this proposal, who is this capturing that gets an attorney that isn't already having an attorney appointed? The fiscal note, they've identified that there are no additional costs to the state. And it says no fiscal impact, and they aren't inclined, the fiscal office was not inclined to identify this as a mandate because there's a presumption that the court can rebut, and also it's unclear how many people would be receiving appointed attorneys under this who aren't already. But this is kind of a philosophical discussion initially, the presumption of representation. And so I know Kathy Ayers is on the call. Judge Washburn from Somerset County also was invited to participate in this call for this bill. And Leo Delicata, who helped me draft this for you, is also on the call. So I'm sure you have lots of questions, and I'll try to answer as many as I can, but you also have some experts on this call that will really help you.
Thank you. Senator Bellows.
Thank you. My question is for Kathy Ayers, because I know, so I come from a county that is having some fairly controversial and challenging budget discussions. And I think that we're entering into a fiscal environment where there's going to be just so much stress on the state budget, but also local and county budgets. Kathy, I know our fiscal office doesn't calculate or didn't wish to calculate a cost, given the difficulty because there's not a cost to the state itself, but there's certainly a cost to the county. Can you talk just for a few minutes about that cost in Kennebec County, which you serve, and I thank you for that, but also across the state?
Sure. Well, what I can guess about how much more this would cost is just a guess. But we have actually, all the probate courts have asked for more money in legal funds because of the new code. And that is causing a lot of issues. I'm going to say, and also, besides that, I'm guessing it's going to double. I think it will double what we're paying now, which would be in my county, would be from 45 to 90. That is my guess on that. But it's also the procedure and process and availability of lawyers, because we're having difficulties now with the 14-day hearing in an emergency, finding attorneys that can be ready for trial in 14 days. And it's also going to, in my opinion, cause delays for people unnecessarily. And that's also an issue, as Leo knows, with getting people out of the hospital into nursing homes, because the judges are going to have to make a finding before they could rule on anything like that. So I do think it is a big fiscal no. I do think the jails are taking everything the county has, and there are angry mobs about our budgets. So, you know, I want people to be represented. That's where I'm coming from. So, but that when we have people like husbands and wives, and someone needs to go to a nursing home, that's going to cause delays for somebody who necessarily does not want it. And I understand there is a presumption, and it's totally up to you, but it is going to impact. It is going to impact the county taxpayers, and they're not very happy right now, as you know. So that I'm going to stop rambling now.
Thank you, Kathy. Other questions by members of the committee? Representative Cardone?
Yeah, I see Mr. Delicata raising his hand, and I would like him to speak to the committee. He and I have had discussion about the importance of this, and I was just looking through this testimony to refresh myself, and I think there's some I haven't seen here. I think there's a written testimony that was submitted by people who didn't show up in person, and I think there's a real misunderstanding coming through in this testimony about what the role of an attorney is in this process and what is at stake. And I know Mr. Delicata can address that, and I'd like the committee to hear from him.
Certainly. Mr. Delicata, join us. Can you hear me? You're muted. Hmm? No? I don't think so. There you go. Oh. Hold it. You're still muted, Leo.
I leave my damn.
I don't know why he is.
How's that?
There you go.
All right. Okay, great. Thanks. First of all, thank you for inviting me to be here. I really appreciate the opportunity. And I do think this is a very important decision that faces you. You know, for me, it's always been about the liberty interest that the individual has at risk in these types of cases. Remember, we're talking about the possibility that an adult, because of some perceived physical or cognitive issue, would lose their adult rights. And in fact, in the worst case, be reduced to the legal level of a child. That's a really, really serious piece of trouble to be in. And the idea that somehow people who are faced with that risk do not deserve the same kind of help that somebody facing either a commitment to a mental health facility or jail has always impressed me as being not understandable. There are cases, and the way the law is written now, it's very good at being able to at least present the possibility that somebody will discover that the individual facing this kind of risk either objects to the proceeding to begin with, or objects to some limitation that they understand that they're going to have on their life as a result of having a guardianship or a conservatorship imposed or other protective proceeding. Now, what it doesn't do is it doesn't take into consideration some of the people that we see, which is those people who are isolated but for one person in their life who has taken an interest in them and who has petitioned for guardianship or conservatorship. And the problem is that these people are afraid of losing this one person in their life that is of help. And yes, they may have some kind of diminished physical or cognitive capacity, but they're perfectly ready, willing, and able to talk to somebody, but they're not ready and able to say anything bad or to refuse anything that this individual would want. Now, financial exploitation is a big problem. And the problem with it, and one of the problems with it, is that it is perpetrated on people by family members or close people who have had close association with them. These are exactly the kind of people that would petition for a guardianship or a conservatorship, and exactly the kind of individuals who would be afraid of saying anything if faced with this risk. What this amendment does is it says the presumption is that if you're facing this kind of risk, you're entitled to an attorney. But if the court finds by clear and convincing evidence that you knowingly and intentionally are going to say, no, I don't want this to, I don't want an attorney to represent me. I'm fine with this whole proceeding. And that may happen in a case where somebody has Alzheimer's disease and they may join in the petition, or their family may bring a petition, and they're very happy to bring that petition forward. And so they don't need an attorney because they understand what their life is going to be like. They understand that they need some kind of assistance, and they trust the people, and the trust is well placed. So the other category of person is, and there are a couple of other category of people, are those people who are so advanced in their disease, and it may be Alzheimer's or other related dementia, that they really do need a guardian or conservator, but they're not able to participate really in any meaningful way. And what's the problem there? The problem is that the guardian or the conservator must present a plan to the judge as to what their intentions are, pretty specifically laid out, as to how this person is going to live their life, where this person is going to live their life, if they're going to go to a facility, when they're going to go to a facility, all of that, very important stuff. Now, there are judges, I believe, who think that an individual who has progressed to this level can't be helped by an attorney. What's the attorney going to do? Well, what the attorney is going to do is be an objective voice for this individual and only for this individual. And what that attorney will do is make sure, as far as they can possibly investigate, what this individual's values and individual preferences are. Because those things by law must be reflected in that plan. How do we know? How do we know that the guardian or the conservator who's petitioning, this individual is petitioning, has taken all that into effect? What if it's a child? What if it's an intellectually disabled individual who is is turning 18, and the parents want to protect this individual. And so the plan that they lay forward is a plan that does not reflect the values and preferences of this individual, this kid who's becoming an adult, a legal adult. And who's going to represent that kid? The parents who are actually petitioning? I don't think so. And those are really difficult cases. Those are cases where the now about to be adult deserves to have his or her own voice. And it's not about deserve, it's about entitled to have their own voice before the court. And in that case, an attorney absolutely needs to be appointed, but not all judges are going to take that particular conclusion. So those are some of the people that we worry about. We worry about the older people who have some limited capacity, but have an individual who's gotten really close to them that may exploit them, and they don't want to say no because they lose that person and they lose everybody in the world. The person who is in advanced disease and really needs somebody to ensure that their values and their preferences are going to be reflected in a plan for the rest of their life. You know, if you actually understand what you are asking the court, or somebody is asking the court, and you wish to not be represented because you may still have the level of capacity in Alzheimer's, for instance, that will help you make those decisions now, but you know that in a year it's not going to happen, and in a year you need a plan in case your wife dies or somebody else who is going to be the petitioner dies. You need a plan that everybody's going to know reflects what you want. So I think this is a fair compromise. I think this allows a court to not appoint an individual in particular cases where they know to the best of their ability that this individual is voluntarily doing this. And there is no other reason to have an attorney. As far as the costs are concerned, look, I respect Kathy Ayers tremendously. She's been in the probate court business for a long time. It's generations in her family. She cares about people tremendously. And she's been of tremendous help to this committee through the probate code rewrites and all of that. I'm not sure, I know I disagree with her as far as the financial effect that this change is going to have on the counties. You know, I went through all of the county budgets for 2020, and I looked at the budgets and most of the budgets were really pretty good because they not only gave you the 2020 figures, but they gave you the figures for 2018 and 19, and gave you some of the budgeted figures and then the actual figures. And she's right, they have increased the amounts as a result of the probate code being passed. And you know, some of the budgets even have a note in them that says we anticipate that we're going to have more business, or the probate code is going to require us to have a more in this line. You know, it's interesting when you look at those budgets in terms of what the ask was and what the actual was. And if you look at even, you know, Aroostook County, for instance, in 2018, their actual was $3,053. In 2019, they budgeted $12,000. And because the numbers were going up, they asked for 14,000 in 2020, but they only got 12. But the 12 was based upon a budget ask of $12,000 in 2018, and they used $3,053. So somebody figured they needed a lot of money, and they ended up not using as much of the money. You look at Cumberland, at York County, and they went way above their budgeted amount in 2019. They went up to $68,000 from 50. So in 2020, they got $84,000 in their budget. Okay.
I don't mean to cut you off, Mr. De La Cara, but we've got to move the work session somewhere, one way or the other.
Okay, I'm just saying that budgets are estimates, they're guesses, and I don't think that this particular change is going to have the same dramatic effect as we heard that the revisions to the probate code for this particular issue we're going to have. I mean, as you remember, we had quite a discussion about all of that. And I just want to point that out. Thank you.
Thank you. Other members of the committee or, oh, I'm sorry. I don't see them. Who are they?
Representative Babbage, Senator McDonald,
Okay.
Representative Cardone.
Representative Babbage. For some reason I'm not.
Sorry, there we go. Thank you.
Oh, there we
Mr.
go.
Chairman.
It's got a little hand now. Okay.
I just, in my discussions with the probate judges, you know, they, I don't want to call it a fiefdom, but they are unique and have this immense responsibility, but they're also very fiscally aware of their budgets, which may be a detriment in one case. I'm concerned about, you know, right to counsel being allocated according to budget availability, which is not a charge I'm making, but subliminally it may have an impact on where we want to go, with this. As I look at, I heard a comment that's saying, who are we really trying to favor here with this proposal, if in fact current law says what it says? And then I also heard that by the same reluctant people saying that this could expand the budget significantly. So evidently it would impact some people. But I know the court right now determines that the respondent needs, if they determine that the respondent needs representation, they can do that. If it comes to the court's attention that the respondent wishes to contest any aspect of the proceeding or seek any limitation on the proposed guardian's powers. So they do have those powers now. I'm thinking that what we're trying to achieve is to have an advocate for a person who is unlikely to express it themselves and or unable to, and you know, wouldn't this be a particularly great protection from any kind of abuse for the disabled and for seniors? So,
Is there a question hidden in there somewhere?
my question is, am I accurate in what I've said, or does somebody want to dispute any of that to change my thinking on this?
Anybody care to respond? Representative Reckitt?
I want to respond by accentuating what Representative Babbage has said. I worked for many years with elderly victims of domestic violence, and I got to tell you that this is a serious danger for those that category of people. And I think it's really important that we make sure that they have a voice in the proceedings. I don't believe they'll always ask for it. I wish sometimes they would, and they haven't. But I think it's really important that that population be considered, because when you have a person who's been going for years under somebody's thumb, and God forbid they inherit some money, I mean, it's going to be a problem. So I think we have to consider that particular population as well as the others that Leo Delicata has outlined. And I think Representative Babbage, something you said made me think that even though you didn't articulate that particular population, that you were in fact thinking of that. And here's my question: is that true? This is Senator Keim taught me to always find a question.
You don't have to answer if you don't want to, Representative Babbage. If not, I'm going to go to Representative Cardone.
The answer is absolutely, but I muted myself.
Representative Cardone, and then Senator Bellows.
Thank you. I would like to address the cost issue and the availability of attorney issues that Ms. Ayers has brought up, because I don't know about all the counties, but I do know in Penobscot, where I practice, those are not insignificant issues, and they deserve to be discussed. When we originally brought this bill, not anticipating the pandemic and the financial situation that the state would be in, we were discussing, to go along with it, having these attorneys, not just attorneys, the additional attorneys that would be appointed under this bill, but having all of the court appointments in probate court go under the umbrella of MCILS and therefore get paid by the state. Also, if MCILS attorneys were given a raise from whatever they were, I know the court-appointed attorneys in probate court are getting 55 now. Is that right? 50? She said
60, isn't it?
The 60 is a MCLIS, but it's by county. So most people are doing, we're doing 70 in Kennebec to try to get lawyers.
Okay. If MCILS attorneys did get a raise, I think it's like 55 or 60 in Penobscot, unless they've gone to a raise in the last couple of years. Anyway, if we could get these folks under the MCILS umbrella with training and with a raise, that would eliminate the burdens on the probate courts. I'm not saying that can definitely happen, but it is not, and of course, we have the problem, we have the fiscal problems now with getting out that bill that I think we're going to be looking at in the next general session anyway. But what I'm trying to say is we haven't lost track of that. That hasn't gone away. I would, if this bill passes as is with the let me try that again, presumptive or rebuttable presumptions, I want to keep an eye on the costs for the counties. I know the counties have limited funds. I know they can't go out and just raise taxes to the extent that they want to, and I am concerned about the taxpayer. I would like to know, I will be supporting this bill as revised, but I would like to know for the next session about cost overruns in counties. Are you experiencing something beyond what your current budgets can handle? Are you so diminished in the ability to find attorneys that we need to address the dearth of attorneys, and maybe through MICLIS or through some other program? So I do want to express that these concerns are not lost on me. I do believe that the concerns that the bill addresses outweigh them at this point, but I want to know what the actual results are, and if the state needs to do something about it, to me, it's a big deal, and I want to make sure that we do address it.
So what do you want to do with your bill?
What do I want to do? I'm going to support an ought to pass, or it ought to pass as amended, I guess, with the rebuttable presumption language.
Okay, Senator Bellows?
So my question is for Peggy, but I'm going to preface it with a comment. So one of the best parts of working on this committee is I think so often we do share the same goals. We might just have different approaches. So I want to say at the outset that my questions about budget are not diminishing the importance of right to counsel. It's a constitutionally protected right, and this committee has done some great work in trying to expand access to counsel. I think my question, and I will be opposing the amendment, at least at this time, this year, for this session. Because when I read Title 18C, Section 5-305, right now it says, appointment of attorney required. The court shall appoint an attorney to represent the respondent when A, requested by the respondent, B, recommended by the visitor, C, the court determines that the respondent needs representation, or D, it comes to the court attention that the respondent wishes to contest any aspect of the proceeding or to seek any limitation on the proposed guardian's powers. And what I couldn't find in my folder, I read the testimony. Leo, you've been very eloquent, and I deeply appreciate, I mean, you have a wonderful and it's distinguished career in legal services for the elderly. But what I couldn't find is data in our folder about where, because the probate judges and all of their comments said, we do this all the time. We appoint an attorney if there's any indication that the respondent is not in agreement with what's happening. Did we receive any data or any news articles or instances where legal representation is not being provided to these vulnerable populations?
Thank you. Peggy, do you know where we're likely to be going here?
Right. I don't know that we have any, I don't know that anybody has done a scientific study about it or collected information about situations in which, kind of like Mr. Delicata was describing, where where they haven't expressed any concerns about the appointment, and yet because they don't want to lose the one person who's taking care of them. I mean, I don't know how you track, how you identify and track that data. I think every single probate court judge said, if somebody says that they have a concern about this appointment, then about the appointment of the guardian or the conservator, then they are getting an attorney appointed. I think another one of the concerns raised was that if the individual has money, has an estate, then that comes out of it comes out of their estate as opposed to the county pays for it, I believe. And so if you have somebody who has resources, the concern is appointing an attorney over their objection to using their resources for that. I think that's one of the concerns. But really, no, Senator Bellows, we do not have information about when an attorney was not appointed and should have been. There might be cases, there might be anecdotal information, I guess, but I don't know of any information that was provided to us that, you know, has been collected. And I see other people want to talk too.
Mr. Chair, is a follow-up appropriate or not appropriate? I can wait.
Representative Harnett.
Thank you, Mr. Chair. I would just like to give Mr. Delicata a chance to answer Senator Bellows' question about cases that he has seen or concerns that he has about people not getting representation when he felt it was appropriate or necessary. I'm sorry.
Mr. Delicata, are you still with us? Oh, there you are. Okay.
Yeah. To answer that question, I'm going to read the answer from one of the probate court judges, and I'm not going to identify who this judge is, but you have that in writing as one of the comments that was made in response to this amendment. And this is what he says. After basically saying, you know, we have wonderful visitors and of course we'll appoint attorneys wherever we think they're necessary. It seems to me that our adult guardianship tends to fall into two categories. The first category seems to be young adults who have mental health issues or intellectual disabilities. In many of these cases, an attorney can be of great assistance, and I think we appoint them when needed. Not we appoint them, we think we appoint them when needed. This is the second paragraph. The second category tends to be older adults with dementia. By the time a petition is filed with the probate court, the dementia is often severe. These unfortunate people often cannot state their date of birth or the names of their parents or children. They have no idea what medications they are on. Unless there is a suspicion of abuse by a family member or caregiver, I don't find that any attorney can provide much assistance to these people. It doesn't say he's going to appoint an attorney in every case. He's only going to appoint an attorney if somehow there's a suspicion of abuse by a family member or caregiver. Well, where's that going to come from? Those are the kinds, that is precisely why I'm so troubled by all of this. Because I know that as has been suggested here, that all of these judges are people who care. There's no question in my mind that every single one of them are people who care. Every single one of them has a conflict of interest. Every single one of them has a conflict of interest. They are employees of the county. They are beholden to the county for the money that is budgeted to their court. Tell me that won't influence them. Tell me that that doesn't influence them. Tell me that when election time happens, that's not a concern, because those are the only judges that are elected. I apologize for my phone ringing, but so in terms of data on financial exploitation is extremely difficult to come by. You know, the Department of Health and Human Services and Legal Services for the Elderly, if you don't mind, I got to do something about this phone. Sorry about that. Yeah, you know, we basically commissioned a study by the Muskie Institute on, given the cases that we did and the cases that APS did. And it was very clear that we were scratching the surface as far as the number of cases were concerned, but the amount of money just involved in the cases between the two organizations was in the millions of dollars. This is happening in this state. It happens more than anybody wants to report. The statistical difficulty is a difficulty that is nationally known. And so it's really hard to come up with data which is verifiable data. But what we can come up with is some common sense approaches to how people are going to react when faced with a conflict of interest that deals with a situation where we're talking about the individual human liberties that people may lose. And here we have a judge that's been a judge for a long time saying, you know what? If somebody is in the advanced stages of Alzheimer's disease and they can't tell me what their names are or the names of their kids, or come on, don't we forget things sometimes? But this is advanced Alzheimer's where you can't really tell the names of your kids or your parents or your date of birth or whatever. You're not going to get an attorney in that court unless somehow somebody's going to come forward and say, oh, well, we think maybe they're getting exploited. And if you've only got one person in your life, who's going to come up and say anything? Who's going to appear?
Thank you. Representative Cardone, you're next, and Senator Bellows.
I wanted to respond to Senator Bellows, and I do wish you would reconsider your vote on this. In addition to what Mr. Delicato just described for you, it seems to me if the probate court judges are saying, we're doing a good job and we already appoint attorneys in cases where attorneys are needed, then the worst that can happen by changing this language, because that gives the probate judge the opportunity to scrutinize the case and a standard for a rebuttable presumption. The worst that can happen is that we're going to be seeing the same number of attorneys appointed in the same types of cases appointed, and we're not going to have a cost overrun. If we change this language, and to me, it is it's a better standard and gives the court the responsibility and the opportunity for closer scrutiny. But if we change the language and we see a real spike in court appointments and a corresponding cost overrun, then that suggests to me that the previous language and the requirements that we had in the statute were not adequate. And rather than roll back those requirements, we better be looking for more funding to protect the rights of these people. That's how I analyze this language and its complementary budgetary concerns.
So,
Senator Bellows.
yeah, I just want to respond and sort of more fully explain where my deep opposition comes from. We heard a lot of testimony from the family members, including legal guardians of adult children with intellectual or developmental disabilities about this bill. And I think that there is the potential, an assumption is being made that the attorney will always act in the best interest of the respondent, and that is their ethical obligation. But there was a very powerful 2017 New Yorker article that I just found that made a huge impression on me, especially because I saw a documentary about this issue, where there is an industry in some other states of attorneys exploiting elders by winning assignment to them and representing them, and then utilizing the assets of their estate for their own personal gain. So I recognize that's not an issue here in Maine at this time, but when we have a bill where family members and some, I think that where people have expressed concerns about the content of the bill, where it was very controversial in the public hearing and in the first work session where members of the public could come to the room. And one person emailed me late last night and said, can you allow me to speak at the Zoom? And I said, I don't know how to do that. So I feel at this time, I have some deep reservations given those concerns. I have some concerns given where the probate judges are saying we are appointing counsel. And if I were concerned that right to counsel wasn't happening, then the fiscal concerns would be less so. But I am representing constituents who are deeply, deeply concerned about property taxes. And again, if we're talking about elders and people with disabilities and scarce resources, there's some larger fiscal questions that we do need to contemplate. That's where I'm coming from at this time. So it sounds like I'm in the minority, and that's 100% okay. But I wanted to share that it's not because I don't care deeply about access to counsel or access to justice and about elder abuse.
Representative Babbage.
Thank you, Mr. Chairman. I think that those in the judicial system sometimes rely too much on the adversarial system to placate their consciences. But the adversarial system does have a very important role in getting to understanding and positive results, justice. And I think the use of counsel in this case creates an adversarial system where one might not exist. But to placate my conscience, Mr. Delicata, could you tell me how, so that I would have a better understanding, how would an assigned counsel benefit a person who is incapacitated to a severe degree with dementia? In other words, what is, I mean, the probate judge that you cited, I don't think saw a positive role there. Can you help me as to what that role might be?
The very first, yes, I'll try. The very first thing that you would do is you would go and see that individual yourself to make sure that you had a firsthand impression of that individual's being. The second thing you would do, and maybe what I would do is I would read the visitor's report very, very carefully. And if the visitor's report didn't strike the same chord that I left that client with, then I would be suspicious. If it did, I would still try to talk with some of the same people that the visitor spoke with. And if the visitor didn't speak with anyone else or didn't speak with anyone else but the petitioner, I would be, first of all, disappointed, but second of all, have to do more investigation and talk with the neighbor, find out all of the people in this person's life, assuming they had other people in the life. And then I'd look at the plan that the petitioner brought to the court and try to make sure that that plan, as far as the visitor and I determined, reflected the values and preferences of that individual, not anybody else's. And the only way you could find that out is by finding out about this person's life. I think those are the beginnings of what an attorney could do for this individual. It's a verification mission. And it's also a mission that requires you to make sure that the plan going forward really does meet what this individual is desiring or has desired in their lifetime. I mean, I certainly would speak with the medical people too, but bottom line is that, that is probably a little farther down the line than trying to speak with individuals who actually know this person and verifying that the visitor's conclusions are based on fact and not on what the visitor thinks is in the individual's best interest, because that's where the attorney really makes a big difference. The attorney doesn't think about what's in the best interest of this individual. The attorney wants to know what this individual thinks is in his or her best interest. And that's one of the problems that the system has when you have intellectually disabled children aging into adults. That the attorney's job is to make sure that the individual person who's turning 18 gets what they want and not what the parents want. And that causes a lot of conflict and a lot of problems.
Thank you.
So
Representative Cardone? And then Representative Bailey.
I just wanted to make sure that Ms. Ayers is heard. I see that she's been raising her hand, Your Honor. And I do want to just respond briefly to Senator Bellows. I think we had a longer discussion about this earlier on, but the article that you read is about the attorneys seeking guardianships is not the situation that we're talking about here. We're not talking about when the attorney goes in and petitions. Well, I take that back. Maybe we might be having another attorney appointed in order to scrutinize the petitioner, whoever that may be, motives may help curb something like that. But it is, we're not talking about the specific situation when it's an attorney or a business that's coming in and petitioning. But I want to make sure Ms. Ayers is heard.
Thank you. Ms. Ayer, you had something you wanted to add? We need to bring this to a conclusion.
Sure, I just wanted to say two short points. And one is, I don't think you've let the new code have enough time on this. I really don't, because we are now tracking. We are now having reports that are required every year. We are now tracking these people. These people have to be in the hearing now. So they are told, if you want, they are asked if they can, if they have an objection, if they want something else, and told that they can come back to court at any time. So I understand where you're coming from. Like I said, I'm all for, and the availability of attorney is number one for me, because we're not finding them. What do we do if we have no one to take the case? Where do we go if you make it mandatory? And the other thing is, of course, that Leo's cases are not probate court cases. I'd be very shocked if there were a lot of guardians doing this, and I'm sure there are bad people everywhere, I'm finding out. But I think that there is a difference between abuse among the general public and abuse among people in probate court, and that's all I want to say.
Representative Bailey.
Thank you, Mr. Chair. I just wanted to respond to Representative Babbage's question, just in terms of, what an attorney might bring in a situation. I can share with you one case I remember where I was court appointed to represent an elderly adult who had Alzheimer's, dementia, and was clearly incompetent. But as her attorney, and as Mr. Delicato was saying, I got to know her. And one thing I got to know when I got to know her was that her faith was very important to her. And so what I advocated for was not that there shouldn't be a guardian appointed, but that guardianship order should take into account her beliefs and her faith. And so we put right in the order some provisions that addressed things that had to do with her faith. So that's just an easy example of what having an attorney, an advocate for someone can bring to the table. She wasn't contesting the guardianship. She didn't even realize she could ask for things like, oh, could you take into account if I have to go into the hospital, you take into account my faith. But I was able to advocate for that. So I just wanted to share that, if that helps you understand a little better.
Thank you. I would move ought to pass as amended.
Do I have a second? Representative Cardone? Any further discussion? So we will need you, Senator Bellows, Representative Cardone, and Darlene to make your way to the chamber, please. We'll pause while you're doing that. Committee back to order. Pending motion before the committee is ought to pass as amended. And I would ask Ms. Simoneau to call the roll, please. Yes.
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 No.
Yes.
Yes.
Okay, 7:01. Folks on Zoom, you have 24 hours. Thank you.
I just need to clarify when Senator Bellows gets back to her, back to the chamber where she's sitting, whether her vote is an ought not to pass. So when she sits down again, I'll clarify that.
Excuse me, I'm going to ask Representative Carpenter, could you put your microphone on when you're speaking? Because the last couple times you haven't, I can't hear you.
If there were a Representative Carpenter here, I would ask him to turn his mic on. Can you hear me now? Can you hear me now?
Yes.
And it's possible, it's entirely possible that I didn't have it turned on, Barbara. I apologize.
Well, I'm assuming you didn't because up until now I was able to hear you, and then you said something that was, I just couldn't, completely gone. So I'm assuming it was for lack of a microphone.
Where's my bill? I don't have the bill in here.
Senator Bellows, I just want to clarify that you oppose the ought to pass as amended vote.
That's
So
right.
I'm assuming you're ought not to pass, or do you have a different amendment?
No, no, it's ought not to pass. Thank you.
Okay, well, I don't have it. All right, so I know, that's fine. Next, we're going to take up LR 3299, I'm sorry. And we don't have that in a folder. Peggy?
You don't have that in a folder, but it's in your clipped packet that was on top, or maybe even in your accordion folder. And your accordion folder is actually your indigent legal services folder. So if you want to start looking at the Sixth Amendment Center report and anything else, you should have that. I did email it to everybody in addition. So the last two things on your agenda, at least I think they're the last two, are proposed bills that you asked for a joint order to report out to the floor way back in, in March, the end of February, beginning of March. You started talking about some of the recommendations you wanted to go forward. And one of the things that's still pending is a study group on the right to counsel. That is still pending, that we need to work on eventually, but not today. So LR 3299, you decided you wanted to address two things right away. One is the Sex Amendment Center's recommendation for MCILS to strengthen the attorney qualification and training requirements. And that's what LR 3299 is addressing, because MCILS has rulemaking authority now to do that. Those rules, however, are major substantive rules. Major substantive rules, they go through the regular rulemaking process. When they get to the end of that, they provisionally adopt the rules and then they submit it to the legislature. So that means they would have to wait until January. They have to be submitted on time by the middle of January. And then they can't go into effect until the legislature basically has a look at them. And what you had agreed to was giving MCILS a window of routine technical rulemaking for these attorney qualification rules. And you had originally said, let's do that, let's make them routine technical until July 1st, 2021. That'll get them through, the rest of this year and most of the first part of next year. And then we didn't get this bill out the door, so there's still major substantive rules. And MCILS met last week, and I asked them to look at this, and they said it would be really helpful to them if you could just give them a few more months, change that revert back date to October 1st, 2021. And so that's what you have in front of you. Also, when I sent this out for review to all of you, Representative Harnett raised a question about the word disservice. I have that circled on line 9 in the whereases. He thought maybe a better choice of words there would be challenges, the existing challenges to those in need of high quality attorneys. So that's what I have. You had originally voted to send this directly to the floor without a public hearing. I think you believed that there was plenty of discussion and opportunity for the public to weigh in on this as you work through the Sixth Amendment Center report.
Thank you, and I agree with the change from disservice to challenges. Representative Harnett. Microphone.
Thank you, Mr. Chair. And I'm happy to hear that you agree with the change. My reasons for the changes, obviously, this is an important thing that we have to move forward. I have grave concerns about the information that came out in the Sixth Amendment Center report. I just don't want to put us in the position of making concessions in whereas clauses that could come back to haunt us if there are challenges to the current system, not weighing in on whether those would be appropriate or not, but let them be decided at that time, not now.
Other committee members who wish to? Oh, Representative Reckitt.
I went to the, or participated in the meeting of the MCILS committee and was totally convinced of the necessity for this particular amendment. And I hope that everybody will indeed support it. My question is maybe not relevant, so you can shout me down, but do you know if LD 1067 is in our hands or somebody else's? Is the other question. Maybe there's a question for Peggy, but on this particular amendment, I'm wildly in favor.
Yes, LD 1067 was a concept draft to put into place any of the recommendations from the Sixth Amendment Center. You were using that to develop a study group on the right to counsel, a pretty high level group to look at the right to counsel and look at all these other issues that the Sixth Amendment Center was identifying, including the development of a public defender system, either, you know, as in one county or other places in the state. So that you were pushing into LD 1067. So all the other recommendations that you felt were worthy to go forward would be taken up by that study group.
Which is later on?
Which is, hopefully we'll be talking about that on the 24th.
Okay. All right.
It's
Sorry.
supposed to be a language review because you voted, but I don't, we didn't really have the complete fiscal analysis at the time. So you really will need to look at that.
Okay. Thank you very much.
Yeah.
Any other questions or comments about LR 3299? If not, I'm looking for a motion.
Do we have to make a motion to do what?
Question?
Senator Bellows?
I really appreciated what Representative Harnett said, and I don't see that challenges has been added. And if we move ought to pass as amended, I just would hope that we would be looking at the amendment with the actual crossouts, but not that particular piece. And I think because I'm not in the room, I can't make the motion.
Go ahead, Peggy.
Okay, I was just going to say I'm happy to, you know, mark it up and share it. I think in your packet, it was in your packet, but I didn't email it out because Senator Keim is also asking the same question about what's that other change. So in line 9, I think the recommendation is to cross out the word disservice and replace it with the word challenges. And yes, that's the one, Representative Babbage.
So we have to report this out like a regular bill or direct you to convert it into an LD, correct?
So what you last voted was to send this out as a new LD that will go to the floor. It will not be returned to committee for hearing or anything. That this is, you've done all that. You have the authority to report this directly to the floor. So once you sign off on the language, and I'll let you see the final version with these changes in it, of course, then it's ready for a vote on the floor. Was that your question?
If the only change you're going to make is take out the word disservice and insert the word challenges, Do we need to have it come back to us again? Okay. All right, then I'm looking for a motion.
Oh, I'm really confused. I thought Representative Harnett didn't want to replace disservice with challenges.
No, he does.
He does.
He
Oh, okay.
does.
Yeah.
He's concerned about making a statement in a whereas.
Okay.
That-
Whatever. Sorry. Great. Okay.
So Peggy, procedurally, do we have to vote on this?
I think that it would be a great idea. Sorry, everybody who has to move to vote on this again, partly because of the dates, but also the disservice changing that,
Right.
because I think that could have ramifications down the road.
So Representative Babbage, Senator Bellows, on your horse.
And did
Ms.
anybody
Simoneau?
make a motion? I'm sorry.
Not yet. We'll wait till they
Okay,
get here.
thank you.
We'll wait till they get here. And Ms. Simoneau, if you're listening. Right. You think of something. Peggy, what would you like to see for a motion?
I think that if you want, you have to do two. Well, so, you know, I don't think Ms. Simoneau is going to have a voting sheet for this because this is an LR.
Right.
And committee clerks don't usually track votes of things that aren't LDs or confirmations. But I think it's a good idea for at least my records, and she can put it in because she won't even have a file for LR 3299.
So would
You
it be
did vote. In my records, I have that you voted to unanimously to report this out. So I guess I would like to see a reconsideration, and then if you want to make these changes, I guess it would be an ought to pass as amended.
Representative Hagan and Senator Keim, are you all right with that procedurally? Okay, thank you. And Representative Reckert, wherever
Yes.
you are, there you are. Thank you. All right, I think the parties are all in the chamber. So I would look for somebody to make a motion to reconsider. Representative Bailey, seconded by Representative Harnett. Any discussion? All in favor of reconsidering? All opposed? Thank you. 8-0 on that. Now we're going to, I'm looking for another motion ought to pass as amended. Representative Harnett, seconded by Representative Talbot Ross. Any discussion? All in favor? All opposed? All opposed? Okay. Thank you.
I'm assuming that was unanimous. That was a unanimous vote, right?
Mm-hmm.
Okay, thank you. Okay, are you ready to move on? Or, oh no, we need to wait till they get back to their rooms.
Senator Bellows on one leg is quicker than Chris Babbage on two.
But he has to go upstairs and I don't.
I didn't quite hear that, but I know it wasn't flattering.
All right, let's take a look at LR 3300. I notice that we have District Attorney Sarback, welcome, with us on behalf of the Prosecutors Association on this one. Peggy?
So LR 3300 is also a recommendation of the Sixth Amendment Center. And it is addressing the question about defendants' right to counsel. And it creates a new section in statute that provides that that prosecutors are not supposed to have any kind of communication with uncounseled defendants until defendants have actually knowingly and willingly, is what this says here, and I'll come back to that, waived their right to counsel. And so that's part of this. And then there's also, so that's the lead-in paragraph. A prosecutor may not communicate with an unrepresented defendant unless these 1, 2, and 3 are met. 1 is the defendant has been informed of the defendant's right to a court-appointed counsel. 2 is there has to be a statement by the court to the defendant that includes the following things: the substance of the charges against the defendant's right to retain counsel, the defendant's right to remain silent, the maximum possible sentence and any applicable mandatory minimum sentence, and the defendant's right to trial by jury. And then 3, the defendant has executed a written waiver of the right to counsel in each case. So if 1, 2, and 3 are checked off, that's when the prosecutor can communicate with unrepresented defendants.
Thank you. And we also have a letter, an email from David Carroll at the Sixth Amendment Center, recommending a small change, that instead of knowing and willingly in line 4, we change that to knowing, voluntary, and intelligent, which is the Supreme Court standard, I believe. Everybody have that? District Attorney Sarbeck, did you want to weigh in on that? Have you seen this? Yes, Representative Harnett had his hand up. I'm sorry. Do you want to? I'll do my committee members first, and then we'll come back to you, Representative Harnett.
Thank you, Mr. Chair. This is a concern I expressed to Peggy in an email when we received this for review. I'm very concerned with the term video recording in subsection 2, given that the information that is required to be provided to the defendant is unique to his or her case, specifically with respect to the substance of the charges against the defendant, and also in D, the maximum possible sentence and any applicable mandatory minimum sentence. I do not see how we could have a uniform video recording unless we have one for every single potential charge that could be levied against the defendant in our system. Putting aside for the moment my concern about the use of video recordings generally, because we're not quite sure if they're listened to, understood, or if people are even following along. In this instance, I see that there could be no use of a video recording, and I would ask for something via video stream or in live and open court. I just am troubled by those 2 words. I hope that's clear.
Well, there does seem to be a bit of inconsistency in that, as you say, when you get down to possible sentence and applicable mandatory minimum and all of that, those are going to be unique charge to charge to charge, and the video recording is not going to cover that. So it seems to me either D has to come out or the video recording has to come out. Am I? Representative Cardone, you want to weigh in?
I actually had another question, so if you want to continue the video recording, I'll hold off.
Okay.
Although I believe Julie Finn is on, we do use video recordings, the standard video recording. So if we changed that wording, does it mean the courts can no longer use video recordings? That might be a bigger step than we want to take right now. That would be the only question I would.
I don't think it would mean that this court couldn't use a video recording generally for an understanding of a defendant's rights. However, it would seem to me that prior to an unrepresented defendant discussing his or her case with the DA, that defendant would then have to come back for a second consult, if you will, with the face-to-face with a live judge, at least at a minimum because of paragraph D. Let me touch base with the district attorney, Mr. Saab. Is District Attorney Sarbeck? Do you want to weigh in on that?
Yes, Senator Carpenter. I think actually, in reality, what would happen? Well, what happens now in most of the courts, and I think all the courts are like this now, is that basically on walk-in arraignments, you have an individual comes in, or many individuals come in. They hear from the judge. The judge informs them of the court system, what's happening right there. Their rights. Then they watch a pre-recorded video that the judiciary has provided. And then at that point, the court takes a recess, and the DA's office has provided the lawyers of the day with the discovery in each one of those cases. And at that point, the defendants have an opportunity to speak to the lawyer of the day, receive information that they have gotten from the lawyer, any offers that are going to be given to them, and then the court starts back up and they have an opportunity to talk to the judge. With regards to the language that says video recording, I think it would be basically impossible to have a pre-recorded video that is going to go into the substance of each charge for each defendant, because as pointed out, you wouldn't be able to basically hit every single charge for each particular defendant. So the defendant under this language, I think, would actually have to speak to the judge about the substance of what the charges are on the complaint or the indictment, most likely just the complaint. But they would have to speak to the judge prior to speaking with any prosecutor.
I have sat through the video recording. I've watched Buddy Murray and Andy Mead do this hundreds of times. I don't know how to get around this unless you leave it to the prosecutor, and that may be problematic for some. The two issues seems to me are subparagraph A, the substance of the charge, because that's going to be unique to each individual, and D, unless you leave that, and again, this may be problematic, unless you say to the prosecutor, you can't talk to this person. Okay, so the judge comes in, he says, okay, we're going to listen to the rights now. You're going to hear a recording. You need to pay attention. This is going to tell you what your rights are. And then the judge leaves, the recording plays, and then you have 40 defendants, 6 of whom want to dispose of their matter that day. They want to get out of it. They don't want counsel. I understand. So what you could do, again, maybe problematic, you could require the prosecutor, and this could be included in the written waiver, to make sure that the substance of the charges are explained to the defendant and Donna's shaking her head, and the maximum penalty and any possible mandatory minimums. Okay, I'm just trying to figure out a way around. I can see that was received warmly. So what would your suggestion be in order to make this a workable system, but yet at the same time protect the rights of the defendant? Representative Harnett, and then I'll go to Senator Bellows and then Representative Cardone.
Thank you. I think the video recording cannot address all of the criteria clearly, so it needs to be supplemented by an explanation live and open court with respect to paragraphs A and D, or via a live video presentation. I don't think it should come from the district attorney because that just feels wrong to me. And I think district attorney recognizes the problem with the video recording not being able to cover all of these items. But I don't think it's an insurmountable problem. And Peggy has a wonderful way with language to fix that all up for us. But I just want to make sure that A through E are covered before a defendant is talking to an ADA.
And you think there's no way to do that other than coming from the mouth of a judge?
That is correct.
Okay. Senator Bellows.
So I would like to hear from Mr. Carroll in terms of this question, but my proposal, because I agree with Representative Harnett wholeheartedly, is what if we added the word live before video and changed the word recording to stream to acknowledge that some of these appearances are happening via Zoom or might want to happen. I mean, maybe they're not actually, but might want to happen via live video. Because the recording, that video that already exists, in my mind, that is getting covered with the number one, the informed of right, not by the state, if that makes sense. It says number one, the defendant has been informed of the defendant's right to counsel, a court-appointed counsel. That objective is achieved in the recording video that's often shown. But number two is something different.
Well, but the video.
And I think it's worthwhile to restate the right to counsel and the right to remain silent in person live, either live video streaming like we're doing or live in person.
Okay. Do we have Mr. Carroll? No.
We do.
Yes, good
There
afternoon.
you are. Welcome.
Hi, thank you, Senator. So generally this is how it should work, is the general announcement to the court is absolutely fine for enumerating rights. The problem is that you have to make sure people were there to see it, that they understood it, that they have the ability to make a good choice intelligently. And so you're always going to have a colloquy in front of a judge to make that decision, that the judge says, yes, you're allowed to make this waiver. You're not being coerced. You understand how to do it. So I don't think it's much different. It's not like it's going to, you have to throw out the general video by the court or anything like that. But the point is a judge needs to determine that this person has the wherewithal to make the decision for themselves that they want to proceed without counsel. And so when I looked at your bill, the video part I assumed was, I saw a lot of arraignments done by videos. And I thought that was what it was getting at. But I think the changes that Senator Bellows has mentioned are good ones because it will clarify all the possibilities. The point is you want a judge questioning the defendant to make sure that they are making this decision to go without counsel in a way that aligns with what the Supreme Court wants you to do.
I'm going to jump back to District Attorney Sarbeck just for a second, because you're saying that you don't see how that can work.
Well, I was referring to a video recording giving an individual the substance of their charges for the defendant. That's what I was saying. I don't see how that could work. I agree with Mr. Carroll that you would have to, if you want to pass this bill as is, you literally would have to have an individual stand in front of a judge, hear everything that is within the criteria, and then as the last part, sign that written waiver. Now, as somebody who was a prosecutor down in Massachusetts, and that's where I got my career started before I moved back to Maine, this is how the process works down there. And I've seen it done many times in district court. And once the person understands their rights, waives their right to counsel, they sign that form. That form becomes part of the court file itself. And when I actually moved back to Maine here, it kind of surprised me that that's not what the process was up here. The key is a little bit of a difference though with how Massachusetts works and how Maine works. And I know the Sixth Amendment Center is located down in Boston, so I think they're most familiar with how they do it in the Commonwealth. Is that down in Massachusetts in district court, the clerk's office is basically the ones who take information and probable cause affidavits from either citizens or mostly the police, and then file the complaints, and then those complaints are sent to the prosecutor's office. In most locations in Maine, how it works is law enforcement actually brings those complaints to the district attorney's office, and then the district attorney's office, working with law enforcement, reviews the case and then files the charges here in the court system. So the DA's office are actually sort of the moving body on that, which the only reason I bring that up is because something that hopefully be able to discuss with you at some point is that this could create a system in which we get calls a lot from individuals who basically are saying, hey, my license is suspended, and we would say to them, well, if you get it reinstated, the charges will be dismissed. And this was brought up to me by ADA Maloney and DA Maloney and DA Irving. What that does is that then basically, if they get it reinstated, we dismiss the case prior to that person ever coming to court. And that means that person never actually comes into court, never goes in front of a judge. So as it's written now, we would be basically barred from having any sort of discussions like that if somebody did call our office and ask about an upcoming arraignment.
Mr. Carroll, how do they do it in Massachusetts?
I actually agree with the aims that District Attorney Sarbuck is saying. I think everybody wants driving with suspended license to be a non-criminal diversion approach to getting people to get their licenses back. So I think what you should be looking at is what you need to do to make that happen versus trying to not pass this bill because of that example. Because I think the aims of what he's talking about are ones that we can all agree on, but the majority of these cases are ones in which jail time are hanging over people, and they need to make sure that they're understanding what they're doing before they waive counsel.
Okay. Representative Cardone.
Mr. Sarbeck really articulated the concern that I had, although my concern was broader. As I'm reading this bill, if the defendant pre-arraignment initiates any contact with the Attorney General or with the District Attorney's office, the District Attorney's office is unable to respond. Is that how that's how I'm reading this? So for instance, if I get a summons for a Class E crime and I don't have any prior record, I'm probably not going to go to jail. It may be a significant fine. For whatever reason, I want to plead guilty, or at least make sure I have the wherewithal to pay the fine. And I'd like to talk to a district attorney about what all this means. They can't do that, is how I'm reading this. I have to go to court. I have to go through the arraignment process, unless I want to hire an attorney to do it for me. I have to go to court. I have to go through the arraignment process and the advice process before anybody in the DA's office speaks to me. Am I reading this correctly?
Is that for me, Representative Cardone? Because how I read it, if this gets passed, I'm going to be instructing my office, staff, prosecutors, if we are contacted by anybody who has a pre-arraignment, if anybody contacts them, I'm going to have to tell them that we cannot speak to that person. And I just want to be clear, I'm not saying that the prosecutors are against this bill. I think if the question was asked, we'd probably speak at the end with neither for nor against, but we haven't polled the DAs because we haven't seen the final language yet. But at the same time, I just want to point out, because of what Representative Cardone just mentioned, is that in response to what's going on with the pandemic, I had already, first of all, I already had plans on starting a restorative justice program in Cumberland County. And it was most likely going to be post-arraignment, but because of the pandemic, we started a pre-arraignment diversion program, which because we received an ethical opinion from the Board of Bar Overseers, unofficial ethic opinion that I've shared with John Pelletier, that says that under the main ethics rules, prosecutors are not barred from speaking to unrepresented defendants, that we now have a diversion program, pre-arraignment in Cumberland County, in which individuals are contacted by our office, and I've given the language from these templates over to John, and that says you have a right to counsel. We urge you to contact an attorney. but we're offering you this chance, this opportunity to have a restorative justice dialogue. And if you go through this restorative justice dialogue, then the case is dismissed. So there's nothing about a plea. There's no one giving up a rights. It's just straight up dismissed prior to arraignment. And all we have to do is file a dismissal with the court. And what it's doing a couple things. One, it's giving somebody an opportunity to avoid having criminal charges. Another, it's keeping them from coming into the court system, both from having a permanent record, but also physically coming into the court system, because we were trying to limit numbers coming into the court. And it's also trying to decrease the backlog. So right now, if this does go into law, I would just tell you that we will not be able to do that pre-arraignment diversion program anymore. And if that's what the legislature wants, that's okay. But I'm just want to point out what we're seeing on an everyday level.
Thank you, Senator Keim, and then I see Senator Bellows.
Thank you. And I guess I would be interested in hearing David Carroll's response to Attorney Sarbeck. But my question is kind of around a fiscal note and the fact that seems really unrealistic when I think this is actually going to cost the state a lot more. And then I question our resources. So I kind of wanted to just hear other thoughts and opinions around that from whomever. And I guess, yes, I mean, what else was discussed, that I've been hearing is that some folks definitely want to be able to waive their rights and to move on without necessarily having to go to court. So I, if every single person has to go in front of a judge, that's really time consuming. And I just didn't know, is there a way to go about it where if someone, if this is their first offense or something like that, is there a way where you can choose something that's lower level, that they have more options, or is that still problematic? I'm just thinking about the people that probably do want the option of not going to court, and then wanted to hear again, like I said, some idea around the fact that there's no fiscal note.
Thank you, Senator Bellows.
So I had heard from some criminal defense lawyers about a practice that's happening in wake of the pandemic, where prosecutors are mailing offers to defendants who are unrepresented. And just this particular example says recommended disposition, 48 hours jail, $500 fine, 150-day license suspension. It then goes on to say, please review the offer. If you accept the state's offer, simply fill out the forms and return them to the court. It does say you can take time to consult with an attorney, but then it says you may not argue for less. This offer expires on such date. So I guess the concern I have is this feels like incarceration by mail. And this is, without this law, there's someone who doesn't understand the judicial system, someone who might be under-resourced. How are they to know that they have the right to counsel if they're low income, if they're facing jail time?
Senator Bellows, may I just ask, that's not from my office, is it?
No.
Okay, I just wanted to make sure, because
but
that would be a practice that I would.
Yeah, it is in the state of Maine, and it is within the
Oh,
last
yeah.
months.
No, I can understand your concern with regards to that. And one of the reasons that I shared the template that I put together for an offer that does not have anybody giving up their rights, because like I said, it's a dismissal. And then if somebody doesn't want to participate in restorative justice, they simply come to court and they hear from the judge, and they may get a court-appointed attorney. They may represent themselves, because I have very large concerns with people not getting and understanding that right to counsel, which is very important, which is vital. So I can understand that, and maybe it's a practice that we need to speak more about as prosecutors, and whether or not that's the best practice to do. But that's something that I can't comment on because it did not come from my office, and it would not. We wait to give the offers.
So my question, though, it's not illegal for a prosecutor to do this.
And it's not, and from us seeking that ethics opinion, it's not unethical under the code of conduct as well.
Right. And I guess that's Mr. Carroll, would you like to weigh in on the practice of offering someone 48 hours in jail by letter?
So the right to counsel only attaches if there's a potential threat of jail time.
Yep.
Right. So if the things we're talking about, diversionary practices, restorative justice, all those sorts of programs are really beneficial both to the state for not having to pay for counsel and to the defendants for having better life outcomes. I think everyone can agree those are good things, and I would support what DA Sarbeck is saying on those fronts. The mail-in offer of having jail time and sign it and send it back, that's precisely the coercive type of things we're trying to prevent. And so that is, if they're threatening jail time, even if it's for 48 hours, the Supreme Court says that there has to be a waiver of counsel, that people understand that a judge has decided they know what they are doing. So I think it's a way of saying, look, you have these practices that I saw throughout your state of mostly related to not having enough lawyers of the day. I think a lot of the prosecutors were trying to be helpful to the defendants because the lawyers that were supposed to be there for them weren't. I don't think this is trying to undermine the right to counsel, but it nevertheless does undermine the right to counsel. And so I think there's, I think one way that could be done is if you're trying to avoid people coming to court to settle this stuff, maybe instead of the plea offer being sent to the defendant, maybe there's a way to automatically appoint MCILS to get a lawyer to review that with that person or something along those lines. I just think this idea of trying to move things along without following what the Supreme Court says you must do is just a recipe for trouble. But again, I don't disagree with the idea of there are people that know they're responsible for what they've been charged with, want to get it over with, if they can avoid going to court to do so, want to. We just have to make sure we understand which are the people that are doing that knowingly, voluntarily, and intelligently versus those that may have developmental delays or other things that prosecutors may not be aware of that are signing away things, not fully understanding the collateral consequences of what comes with a guilty verdict.
Thank you. Representative Harnett.
Thank you, Madam Chair. I just want to make clear, I applaud DA Sarbeck using restorative justice and diversionary practices, and that takes it out of the criminal justice system. So I have no concerns about that type of communication because it cannot end up in the deprivation brought about by jail time and incarceration. I'm unaware of the situation that Senator Bellows mentioned, but that sounds very problematic to me when you have an offer that has an expiration date where a person may or may not have the opportunity to talk to an attorney. I don't want to muddy the waters here. All I am concerned about is that defendants who are facing a loss of liberty have a full understanding of all the aspects of the charge and the potential punishment before they are waiving the right to counsel. And I don't think that can be addressed in the generic canned video, and we have to figure out a way to make sure that any waiver is made in a knowingly, voluntarily, and intelligent fashion.
Thank you. I would like to just offer the opportunity. I know Ms. Finn from the judicial branch is here, at least I think she is. And Ms. Finn, did you have anything that you wanted to add to this discussion? There she is. Welcome.
Hi, thank you. And it's wonderful to see you all. It's the first time in a while. So I actually do not. I circulated this bill amongst the judges and the trial chiefs, and we are not objecting or commenting to it today. In other words, we have basically I'd be testifying neither for nor against, I think, if it were a public hearing.
Thank you, Ms. Finn. So further discussion from committee members? Further questions? I'm looking around.
Can I point out something?
Absolutely. Thank you, Peggy.
So when you were working on this bill, you had a gentleman here who had been part of the ABA drafting committee for the ethics rules. And this is actually consistent with the ABA model ethics rules. Maine did not adopt this language into its ethics rules, which is why Bar Council has, rightly looked at what Maine has as our ethics rules and said, yes, you can do this because there's nothing that in our Maine's ethics rules that requires any of this to happen before a prosecutor talks to an unrepresented defendant. And so when you were last talking about this, you were talking about this kind of taking the place of that whoever adopted the Maine ethics rules did not include this requirement of no communication with unrepresented defendants until they've made that knowing, intelligent, voluntary waiver of counsel. And now that you're thinking about that, as to the question about video recording, maybe because we know some of that can be provided in a CAN video recording, your right to counsel, your right to remain silent, that's standard. That's what everybody can listen to. So part of that can be in a video recording. So maybe we talk about a combination of live in open court, video streaming, and video recording to cover all of that. And we assume that what has to be individualized would be individualized by the judge. So sorry, I'm talking about two different things there. One is just this whole idea about an uncounseled defendant talking with a prosecutor without having already waived the right to counsel, and then maybe have fixed the language here.
Thank you, Peggy. And thank you for that reminder that this was taken from the ABA ethical rules. I do remember we discussed that when we first talked about presenting this bill way back years ago, it feels like. Senator Keim, I think you were next.
I would be interested to hear a little bit more about some creative options for possibly not making it so I think David mentioned, could you send those offer letters directly to amicus lawyer and then have them contact the defendant or something like that, some way that if people were inclined that they didn't want to have to go through the court and spend a half a day of their lives doing that there would be some other option that we could still determine that they're waiving their rights knowingly and voluntarily. And then I'm going to just bring up the idea of the fiscal note again, and I'd like to hear some comments around how that, sometimes we get fiscal notes we are shocked at and we think absolutely not, that's way too high. And then I look at this and I think this is unrealistic. This is clearly going to take more personnel time than what we've had in the past.
May I just say something with regards to that? I can report to the committee that District 3, which is DA Robinson's district, Lewiston, Auburn area, Franklin County, Oxford County, as well as Androscoggin, they have a program now in place, which I believe if a defendant has, I think think it might be risk of jail, but also no risk of jail on complaints, that the court is actually assigning them a lawyer or a counsel, which is, I believe, avoiding them from having to come to court, and that discovery then goes to that lawyer of the day. And so that might be a way to sort of get around this opportunity, what you were asking about, with basically making sure that they have counsel. And I believe it's prior to arraignment, and it gives the opportunity for the lawyer of the day to actually plea by authorization, basically send in a not guilty plea at that time and avoid the person from coming in if it's a misdemeanor. So that could be one of those things to look at. I would just point out, though, that I don't know what the financial situation is with MCILS, but I think Senator Kime is correct that that would be more people getting court-appointed attorneys, which obviously might constrict the MCILS budget. I shouldn't say constrict, I should say affect. But then again, that's a question for John Pelletier, I believe, not me.
Thank you. So I have Representative Harnett, Senator Bellows, and then Representative Reckitt. So Representative Harnett.
Thank you. I just want to address the question about the ethical rules. Whether or not Maine adopted the model rules or what the ABA says about the ethics of consulting with a district attorney without representation, none of those rules trump the Sixth Amendment. They don't trump the Constitution. So I'm not sure what the significance is of the presence or the lack of presence of an ethical rule on this issue.
And Senator Bellows.
So two things. I mean, this bill is just about communications between the prosecutor and the unrepresented defendant. And so in terms of the fiscal note, I think the biggest pressures that we're seeing in county budgets and a significant pressure in the state budget are the costs of incarceration and over incarceration. So I'm not concerned. I'm not surprised that there's no significant fiscal note here, because the second piece is that the Constitution requires that the defendant know the substance of the charges and know their rights and the potential consequences. So if everything is working well on the buddy system, that should be happening already, although I don't think it is, according to Mr. Carroll. So I just wanted to put that out there, that I don't see a problem with a fiscal note.
Representative Reckitt.
Well, I'm sort of torn about this whole thing. I sat through the discussion of this problem at MCILS, and it was clear that there is a fair amount of it going on. But on the other hand, I also have heard today a variety of innovative ways to relieve pressure on the courts, and which I'm always in favor of doing. And I'm sort of floating back and forth, changing my mind back and forth as the moments pass. But I'm intrigued by some of the ways that that people are coping with the problem of insufficient representation. So I'm curious as to whether or not what the process would be. It feels to me like we need a whole lot more discussion than we're going to have in the next 10 minutes. And I'm frankly probably going to vote against this bill, but wanting to have it come back to us in the 1/30th so that we could actually listen to all of the possibilities and weigh them carefully, which I don't think I can do today in the next 10 minutes. Check.
Senator Bellows.
So Representative Talbot Ross isn't with us, and I wish she were today, but or maybe she is, but I didn't see her in the chamber. I am deeply concerned that the Sixth Amendment Center did a study, and what they found was that defendants were meeting with prosecutors and agreeing to things without being fully informed of their rights. And that's pushing people into incarceration, into the criminal justice system. And additionally, to have a document that shows that at least one prosecutor's office in the state, potentially more, are mailing out offers of deals with jail time to unrepresented defendants means that in the COVID-19 crisis, we are seeing the expediting of people into our prison and jail system without the constitutional right to counsel. So I actually see it as an urgent need, not like a nice to have or something that we could work on next winter. And I also think we're creating a vulnerability because, again, having been at the ACLU for so long, the Sixth Amendment of the US Constitution guarantees the right to counsel when the state proposes to deprive someone of its liberty. I think that we are leaving the state potentially wide open to litigation at some point, which would be very costly. So I hear you, and I think these innovative programs are great. And at the same time, I'm deeply, deeply concerned about the people that we may be wrongfully incarcerating because we're depriving them of their constitutional right.
Yep. Senator Kime.
Thank you. I understand what Representative Reckitt is saying, just that, she's listening and hearing that there might be options out there for the process of this. I also fall in the camp of thinking that we should make sure that people are hearing their rights and understanding their rights before they make any agreement. But, my concern comes down to how do we do this? How do we actually do this when we're struggling for resources everywhere? So, I think it's necessary. I think that we just need to find ways to make it happen, that we can make it happen. And, as much as I think we all recognize that, Massachusetts has a much larger budget for indigent legal services than we do in Maine. And so I think a lot of what they do there it is, maybe likely better, but it's also all very costly. So it seems that we need to find, a way to make this happen and a way to be creative about making it happen. But I'm not sure that the two things end up in this bill. Like, this bill is about making sure people understand their rights. And I think the way to make that work in Maine's system and within Maine's budget, I think that's up to the courts and MCILS to and the DA's office to maybe get together and come up with some creative ways that we can streamline that process for people that we know actually are out there that want it to be streamlined, not only for the sake of the defendant, but also for the sake of the courts and indigent legal services. It seems that they're separate, even though I understand what Representative Reckitt is saying. It seems that maybe we should come up with better options, but I'm not sure that we have to do that before we vote in favor of this bill.
Representative Harnett. Oh, and Mr. Carroll, I will get to you.
Thank you, Madam Chair. I agree with both senators, Senator Bellows and Senator Kime, that we need to address this issue now in this session and not put it off until January. Constitutional rights are nothing that people should have to wait for. I think with some tinkering and bringing this back with language review, as long as we assure that defendants who are facing the loss of liberty have all of the information in subsection 2, paragraphs A through E, either through a video recording or through a live video presentation or live in court, that we have to have that in place as quickly as possible. I don't want to see any person incarcerated not understanding their rights as a criminal defendant.
Mr. Carroll, I think you had your hand up.
Yes, thank you. I just wanted to make a quick comment, is that by ensuring the right to counsel, it can actually spur on these innovative ideas like restorative justice, because you're not going to be allowing people to do accepting pleas or coercing pleas by mail. So I think this is a way to spur on exactly those innovative ideas that were raised.
Senator Carpenter.
At the end of this process, whatever the process looks like, we're going to ask the defendant to sign a piece of paper. That's acceptable to the Sixth Amendment Center. That's potentially problematic if you can't read, okay? But is a possible middle ground here that the waivers could be individually tailored to take care of the A and D. I mean, is that, we're trying to look for something here that protects constitutional rights and also is not so burdensome that it doesn't allow the court process to continue to go forward. So if the prosecuting attorney, the assistant DA, in preparing the waiver is slightly more than a standardized garden variety waiver, but it would actually have at least language in there, which would then, now presumably this waiver is going to be presented to the defendant by the assistant DA. All right, you're all set to go. You've seen the video, et cetera, et cetera. Here, sign this, is what was anticipated. Now we're going to modify that maybe. Is that something that might work if you said, okay, here's the substance of your charges, here's what you're being charged with, and here is the maximum sentence that you could receive, and there's no mandatory minimum in this case, for just to cover those two. And if you're okay with that, and if you want to waive that and talk to me, then you need to sign it. Now that's going to be the prosecutor and the unrepresented defendant one-on-one. At the end of this process, don't forget, they're going to be there one-on-one, so.
Sorry, Carpenter, can I just comment on that? That would be communication between a prosecutor and a defendant. And I don't think that the prosecutor or the ADA would or should be placed in that position. I think it has to be the court who actually has that communication.
Huh?
It has, I agree, if I may speak. I agree that that's not the role of the prosecutors. It has to be the neutral body, the court, making the determination.
Representative Babbage, you were next.
Okay, thank you. I'm on already. Thank you. Well, we've had some eloquence here. I believe that, I taught the Bill of Rights all my life, case studies and so forth with every class that has gone through in 39 years. And I took at heart the Sixth Amendment Center's recommendations and discoveries as far as I was concerned. And it seems to me that this is an issue that should not be punted until the 1/30th. So I will go forward with this in whatever language we can to make it the best it can be in order that we achieve what we need to achieve. And I guess I'll just stop there, but I think if we need to change wording or whatever in order to come back to this, that's fine. But I think we need to make a decision on it in the 129th. Thank you.
Senator Carpenter, can I just, one thing that I've been thinking about while we've been here, and I don't know if it's my place and you can tell me I'm out of order, but would be something along the lines within this bill or within this language that would actually carve out a situation if somebody did receive counsel or court-appointed counsel prior to coming to the court. Because this language, as it says right now, is that the defendant has to be in front of the court getting this waiver. And from if there was language that was included in here saying that if a lawyer of the day, a defense attorney was appointed and spoke to that person, giving them the right, or understanding the right to counsel, that might be something that could be one of those innovative ideas that might make it so that person didn't actually have to come into court. And the communications wouldn't be with the defendant, they would be with the lawyer of the day with the prosecutor's office. So that might be something that could keep this or allow communication between the DA's office with a defense attorney who's then representing that defendant. That's just something that's been spitballed.
That's a good point, because back when I was doing this, and if I was the lawyer of the day, you always have 4 or 5 stragglers who come in after the video starts. And the judge would also, the judge and the bailiff, the court officer would always ID them, grab them, come to me, say, these three folks didn't hear the video. And so I would take them individually into a side room and explain to them their rights and all that. And I think I would usually have their offers in hand and discuss the offer with them on an individual basis. So maybe that's, I don't know.
So my thought on that, and I see Senator Bellows, you're in the queue, but just responding to that is that I think that those types of things are one of the broader issues for the commission to look at. Because, for example, if we're going to do a pilot program with a public defender's office, maybe the place for that is the public defender's office that someone could contact beforehand. Talking about the pre-arraignment situation, if they want representation. So is it better to direct them to a lawyer of the day, to the public defense? I just think that's a broader question, as opposed to what we're trying to address with this right here is that there was identified a problem of prosecutors talking to unrepresented defendants prior to the time that they should. And we should just focus on that issue, and then these other kind of process issues or collateral issue. I just think that's more appropriate for the commission that is going to be looking at the other recommendations of the Sixth Amendment Center. I think it's too much for this bill to try to come up with that.
But I was talking about the arraignment.
Well, if you're at the arraignment, I'm not so worried, because then you have a lawyer of the day.
That's what I'm saying.
Yeah.
That's what I was saying, the lawyer of the day. No, I was putting the lawyer of the day in the place of.
Right. I think what this discussion was about was pre-arraignment, appointing an attorney immediately,
Okay.
and or identifying a lawyer of the day. So if someone wanted to have discussions,
reach out, yeah.
negotiations,
Okay.
reach out pre-arraignment. But I think that's a bigger discussion in terms of pre-arraignment. I think arraignment, you can always use the lawyer of the day.
Is everybody on the call here comfortable with that? Didn't think that's what I was hearing, but maybe I missed.
So,
Senator Bellows, you were next in queue anyways, so go ahead.
well, what I heard Representative Bailey was saying is that the language as it is works, as long as we add, instead of video recording, video stream. Is that right, Representative Bailey? Yeah. Because this bill is just about unrepresented defendants. So presumably if there's some representation, that it's not about those communications.
But this language is not just about those who want to contact the DA's office pre-arraignment. This is also includes the time of arraignment. And I think I think the way it's written, it's pretty unworkable. I'm agreeing with Mr. Sarback. It's going to make it pretty unworkable when you have. Do you agree with Mr. Sarback?
Well, no, what I was saying that it's unworkable with regards to making a video that's going to be able to give each individual a substance of the charges and the defendant's right by a jury trial. I think you would have to have a judge come in and basically read the complaints and make sure that they understand all the mandatory minimums and maximum sentences that could be handed down, and then have that person sign that waiver.
I have a question.
But again, that's only if an unrepresented defendant wants to have discussions with the prosecutor. So that's a small subset. On arraignment day, you've got 40 people. The amount of people who want to be unrepresented, including by the lawyer of the day, and talk to the prosecutor is a handful of people. I mean, it's a small amount of people that don't want to talk to the lawyer of the day, at least in York County.
Most of them take advantage of the lawyer of the day.
I saw Representative Babbage, then Harnett, then Keim.
Okay, thank you. I'm just trying to understand, if we went forward with the wording as just described, what impact does that have on Mr. Sarback's restorative justice program or the program in Androscoggin County?
I would say that I would have to unfortunately stop my program, but at the same time, if that's what the law changes, that's how we do things. You guys make the laws, and they basically execute them. That's the executive branch and legislative branch. At the same time, though, that wouldn't stop us doing restorative justice. It might come down to an individual would actually have to come to court, either hear from a judge, sign the waiver, and then participate in the restorative justice afterwards, once they have a counsel. So they would get that opportunity, I think, down the road. I'm not saying that this would just basically end the pre-arraignment diversion program, because we would not be allowed to speak to the contacted defendant if they weren't, or I guess if they haven't spoken to the court yet. And I'd have to re-examine this just to make sure and talk with counsel to just, and if they did have a lawyer of the day, whether or not they would be able to still speak to us if that lawyer of the day advised them to pre-arraignment.
And as far as your understanding, of DA Robinson's program, how might this affect it?
I think DA Robinson, and I apologize that I won't be able to speak with authority on it, but I believe DA Robinson's, the program that they're doing in Androscoggin County is that a defendant actually gets assigned a lawyer or a court-appointed counsel from the clerk's office, and then that court-appointed counsel takes a look at the case and either enters a plea of not guilty with the court. So those defendants actually don't come in for arraignment. They plea by mail with the advice of counsel, and that those offers are given over to the lawyer of the day to speak with the defendant about that. So I don't think this bill would have an effect on what's happening in Androscoggin, but I don't know for sure.
Just to clarify, if I may, Mr. Chair, your understanding of the program in Androscoggin is that they make a plea based on advice from whom?
From a court-appointed attorney.
Okay, thank you.
Senator Keim.
Thank you. And I think so I have a couple of questions. One about the pre-arraignment diversion to the restorative justice program. If in fact you're diverting them from jail time, then into this restorative justice program, then they don't have right to count. If they choose that as opposed to jail time, then doesn't that mean they don't have they don't have to have court-appointed counsel, and they're not? Why would they need to waive their rights? They're agreeing to go to restorative justice rather than.
Well, just to be clear, we're not diverting them from jail time. On many of these cases, it's not going to be either a risk of jail or whether or not the plea would be appropriate for jail time. But in this program, there's nothing that says there's an offer of you plead guilty, you get a $500 fine if you participate in restorative justice. It's basically that the participating in the restorative justice program in this dialogue is the case is dismissed. So you never give up your right, you never plead guilty or anything along those lines. And it's a system that in which because there's no plea, we're not asking for any sort of admission or anything along those lines. Basically they're not giving up any sort of constitutional rights since they are not pleading to anything.
So then it seems that if this law passed, that you would still be able to do your program, unless I misunderstand.
I would be very wary about that, only because to me, when a police officer either makes an arrest or writes a summons, and there's probable cause that that person has committed an offense, and it comes to me and we say, okay, we're going to go forward with the prosecution, that right there means that that person is a defendant within the system. And I'd be very weary of talking to any defendant has charges that are coming up, who has not gone in front of a judge and waived that right to counsel with the judge.
So that brings me to the other thing that I was going to bring up, and that is, I feel like we are getting bogged down in process when I think what we really just want to say is that we want to ensure everyone is waiving their right to counsel knowingly, willingly, and voluntarily. So in section 1, subsection 2, where it says statement by the court, what if we just changed it to say the court has provided to the defendant a statement of, and then that list, without trying to limit the court by method? Because then we aren't allowing innovation, whatever that may be, which may be Zoom, or, I mean, we're relying on the court to make good decisions here. And I guess later on, if we find out that this isn't working well and, you know, people are not being treated well, we could look at that and say, well, I guess the court needs more oversight by the legislature. But I think for us to tell them the manner that they need to do this seems unnecessary, and we should leave the manner up to MCILS and the court to figure out. And that way, maybe we can allow innovation and flexibility to kind of come into this without us talking about whether this should be a live recording or a Zoom or by telephone or, you know, a piece of paper. I don't know. That all seems to be getting down into the weeds, when I think if we just give a clear expectation, that then we leave it to the courts to figure out the details.
Representative Harnett?
Thank you. I find myself agreeing with Senator Keim over and over and over again today. And that's a good thing. And while this discussion at an intellectual level is exciting and important, I think we're conflating way too many issues here. This bill is trying to accomplish, or this LR, a very simple thing. Make sure that criminal defendants understand their constitutional right under the Sixth Amendment. And this is the vehicle to make sure that happens inside the courtroom when they are there with the DA and not represented by counsel. I'm actually comfortable with Senator Keim's suggestion. The key is to make sure this information is conveyed. How it is conveyed in a way that leads to a voluntary, willful, and intelligent decision by a defendant may look like different things at different times. I think it's important to act on this rather than to try to solve all of the problems of the criminal justice system and all of the problems raised by the Sixth Amendment Center's report. This was one that jumped out at a lot of people. We have a chance to deal with it today, and I urge us to do so.
All right, are we ready? I'm looking for a motion from somebody. Probably Senator Velos.
Motion ought to pass.
Repeat that, please.
Motion ought to pass as amended in what was presented to us.
Okay, well, this is an LR, and there's some
Oh,
confusion.
motion ought to pass.
Representative Bailey.
Senator Bellows, if you could just clarify for me, we've talked about a number of changes. The first was instead of knowingly and willingly, to use the Supreme Court language of knowing, voluntarily, and intelligent. And then Senator Keim's suggestion was in number 2 to change that to read that the court has provided a statement of. Those are the two that I heard the most discussed. I'm looking around to see if I missed something. Representative Harnett, was there? The court has provided to the defendant a statement of. Thank you. Any other? So I just wanted to clarify what your motion was. Thank you.
Yep. Representative Harnett. Representative Harnett. Oh, you're seconding. Oh, I'm sorry. Okay. All right. So we have a motion on the floor, ought to pass as amended with those two amendments, I think. Further discussion?
Okay.
We now need to gather our troops together. So Representative Babbage, we have Senator Bellows present, so you can.
I got bumped off the Zoom earlier. I didn't know if it was intentional. Oh, okay.
I threw you off again. I'm about to throw Harnett out as well. So. A lot of power in this stuff. I like this. Thank you, Senator Keim, for your contribution. Maybe it's easier to think clearly when you're sitting in your kitchen.
It's easier to think clearly when you can escape to the kitchen for tea and coffee whenever you want to.
Getting faster, huh?
All right, the pending motion before the committees ought to pass as amended. Anybody have any question on what the amendments are? Two amendments. Oh, wait a minute, we're still waiting. I'm sorry. Representative. We're still waiting on Darlene. Sorry.
So I'm wondering, since we did this with LR 3299, do you want to do a quick reconsideration because you had already voted to send this out as a bill? So for my records, I'm not sure that Darlene's going to have the same records, but maybe you want to do a reconsideration real quick and then ought to pass as amended.
Moved by Representative Harnett, seconded by Representative Bailey to reconsider our action whereby we previously voted on this. Any discussion? All in favor? All opposed? Unanimous? Now, pending before the committees ought to pass as amended. Any further discussion on that? Would you call the roll, Ms. Semino, please? Yes.
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 Thank you very much. Does that conclude our work? I believe that, pardon? Oh, hi, Peggy.
Hi, I just want to say thank you for all your work. This is great. I miss being in the same room with you, but this wasn't as awful as I thought it was going to be because I can still talk to you and see you.
Thank you for setting this up for us so we could get it done. Without you, we could not. So we're
You're
next
welcome.
back on Friday next
Yes.
on a series of other bills. So thank you very much. And
right. And
that'll
I'm
do it.
sorry to fill up your inboxes, but I guess that's the best way to do it. And also, if you're in the building and you have an expense sheet, make sure you put it where the chairs can sign it for you. And if you leave it, I think Ms. Semino can pick them up for you. And if she doesn't, I'll pick them up for you.
Thank you very much. You all have a nice weekend.
Thanks.